I'm told there's food. There's food. How would you prefer to deal with it? Want to eat now, 10 minutes before we start? Or we'll just take the food with us home?
No, that's fine.
Yes, sir, so the process is.
Good afternoon. Are we ready to start?
Recording in progress.
Can I then, our agenda for today, presentation of the B bill by the legal advisor, clause by clause analysis of the B bill, consideration and adoption of the bill, consideration and adoption of outstanding minutes, consideration and adoption of the committee report. Is the committee report different from the public participation? Okay, can I then hand over to Nati?
Honorable Chair, good morning, good afternoon to you, Chair, and to honorable members. Chair, as you've already alluded to, we are considering the B bill today. The committee is considering the B bill today, which would be the bill as introduced, incorporating the changes that have been proposed by the committee, Chair, or that have been adopted, actually, Chair, agreed to by the committee. Chair, the process is that I'm going to read the clause, Chair, and indicate the instructions of the committee where the committee instructed us to go and amend, and then put it to you, Chair, to put it to the committee for discussion and later decision on each of the clauses. Thank you, Chair. So, Chair, the first clause in this bill is the amendment of Section 3, capital A of Act 56 of 1978. Chairperson, you remember this is one of the clauses that originated from the committee, and it's the amendment of the Secret Services Secret Services Act. That's the section that establishes the evaluation committee, Chair. I'll read it out, Chair. It reads, Section 3, capital A1 of Act 56 of 1978 is hereby amended by the substitution for Section 3, capital A1 of the following. there is hereby established a committee, comma, within 12 months of the passing of this act, comma, that was the new addition by members, amending that act, to be known as the Secret Services Evaluation Committee, consisting of not less than 3, but not more than 5 persons, appointed by the state president, comma, of whom one shall be designated by him as the chairman, and of whom at least one shall be a holder of office in the executive authority of the Republic, and shall be appointed after consultation with the leaders of the opposition parties in Parliament. Thank you, Chair. That's the first clause.
Honorable Stebe,
Chair, just in this document, within 12, there must be months in it. In the document, there's no months in it. It's just a 12 of passing of this act.
okay, we need an insertion there. That was the first clause and correction. And then Honorable Lagude.
Thank you, Honorable Chairperson. This clause must be removed as per the referral of the report from the House that we need to do further consultation as this committee. Thank you very much.
Honorable Kola Barnett.
Yeah, I understand what's happened, but I'm a bit confused in that I thought the evaluation committee already existed in legislation. So I'm not sure what the issue is because we're simply repeating what is already in legislation, or am I incorrect?
Nati,
Thank you, Chairperson. Chair, the act provides for what is there, Chair. The only addition which the committee had proposed is the time period, or is the period within which the committee must be established, Chair. Because that is the missing element in the act as it currently pertains, Chair, the Secret Services Act. Thank you, Chair.
Honorable Lagude.
Thank you very much, Honorable Chairperson. As this were referred back by the House, back to the committee for further consultation, I just want to plead with my colleagues that let's allow for that. We don't want to have a bill which will be rejected in the House because of small issues. Those matters can be dealt with in the next Parliament. Thanks, Chair.
We are, so it's the clause. We agreed on it. A mover and a second.
Yes, I moved it.
Seconder.
I second, Chair.
Thank you. Thank you very much.
Thank you, Chair. The second clause is the amendment of Section 1 of Act 39 of 1994, as amended by Section 1 of Act 37 of 1998, Section 24 of Act 66 of 2000, Section 1 of Act 67 of 2002, as well as Section 1 of Act 52 of 2003, and Section 1 of Act 11 of 2013. This clause, Chair, reads as follows. Section 1 of the National Strategic Intelligence Act 1994, Act 39 of 1994 is hereby amended. A, by the substitution for the definition of agency of the following definition. Agency means the members must please note that what is in square bracket and bolded, Chair, is what is going to be omitted from the legislation, and that which is underlined is what is going to be inserted in the legislation or added. So, Chair, continuing to read, it means the South African Intelligence Agency referred to in Section 3 of the Intelligence Services Act 2002, Act 65 of 2002. And by the insertion after definition of cabinet of the following definition. Center means the National Communication Center referred to in Section 5 of the Intelligence Services Act 2002, Act 65 of 2002. C, by the deletion for the definition of covert, by the deletion of definition of covert collection. D, by the insertion after the definition of crime intelligence of the following definition. Cybersecurity. Chair, this is a new definition. It means the practice of making the networks that constitute cyberspace secure against intrusions, maintaining confidentiality, availability and integrity of information, detecting instructions and incidents that do occur, and responding to and recovering from them. E, by the insertion before the definition of evaluate of the following definition. Espionage. Espionage means the unlawful and intentional communication delivery or making available of classified information to directly or indirectly benefit a foreign state, persons or institutions. F, by the insertion before the definition of intelligence of the following definition. Infrastructure. Infrastructure has the meaning ascribed to it in the Critical Infrastructure Protection Act of 2019, Act 08 of 2019. G, by the insertion before the definition of minister of the following definition. Intelligence gathering. Intelligence gathering means the acquisition and processing of relevant and reliable information into intelligence products relating to any domestic or foreign opportunity or threat to the advancement and protection of national security. H, by the insertion before the definition of national intelligence estimate of the following definition. National critical information infrastructure. National critical information infrastructure means infrastructure products or systems used to receive, transmit, and store information and communication that have been identified and declared as critical for the socio-economic well-being of citizens and which are necessary for the protection of the national security of the Republic in terms of Section 2, Subsection 2, capital B of this Act. I, by the substitution for the definition of national intelligence structures of the following definition. National intelligence structures means A, NCOP, B, the intelligence division of the National Defense Force, established under the Defense Act of 2002, Act number 42 of 2002. C, by the intelligence division of the South African Police Service. D, the agency, and E, service. J, by the substitution for the definition of national intelligence of the following definition. National security intelligence. National security intelligence means intelligence which relates to or may be relevant to the assessment of any opportunity or potential opportunity or threat to or potential threat to the national security of the Republic in any field. Chair, I must just mention in respect of that, we've simply received so we just received these proofs just before we came to present here, Chair. The service provider that's doing the typesetting took a bit of time to finalize. I've noted, Chair, that the instructions of the committee were to remove potential threat and potential opportunity and retain only opportunity and threat. So we will note it, Chair, for further editing. Chair, that is in J, and we must apologize for the inconvenience caused by the service provider, Chair, in this regard. K, by the insertion after the definition of NCOP of the following definition. Opportunity. Opportunity means, and Chair, you will note here that the definition that's been removed used to be opportunity and potential opportunity. And by instruction of the committee, we've removed potential opportunity because it's inherent in opportunity, the potential opportunity, as per members' instructions. So it reads as follows, Chair. It defines opportunity to mean subject to the Bill of Rights and the principles enshrined in the Constitution, such capability, measure or activity employed to pursue and advance national security in accordance with Section 198 of the Constitution. L, by the substitution for the definition of relevant members of national intelligence structures of the following definition. Relevant members of the national intelligence structures means A, Intelligence Division of the National Defense Force, B, Intelligence Division of the South African Police Service, C, the agency, and D, the service. M, by the insertion before the definition of security competence of the following definition. Security competence assessment. Members would note this is where it used to read security competence test. It means administering a vetting investigation to determine the security competence of a person or institution, and if such person or institution is suitable to access classified information or critical infrastructure of the state, or is viewed as vulnerable to blackmail, undue influence or manipulation or security compromise. And by the insertion before the definition of South African Police Service of the following definition. Service. Service means the South African Intelligence Services referred to in Section 3 of the Intelligence Services Act of 2002. O, by the insertion before the definition of vetting field work units of the following definition. Threat to national security. It includes any action or omission which may potentially cause damage, harm, or loss to the national security. Full stop. P, by the insertion after the definition of vetting investigation of the following definition, verification services. Verification services means services designed to identify the origin of the integrity of an information and communication security product, system, or service. Thank you, Chair. That is clause 2 of the bill.
Members? Any mover? Honorable Stepe? Seconded by Honorable Korabanat.
Thank you, Chairperson. Clause 3 is the amendment of Section 2 of Act 39 of 1994, as amended by Section 2 of Act 37 of 1998, Section 2 of Act 67 of 2002, and Section 2 of Act 11 of 2013. This is Section 2 of the National Strategic Intelligence Act 1994, which is hereby amended by the substitution for subsection 1 of the following subsection. 1. The functions of the service shall, subject to Section 3 and Section 2, subsection 2, capital B, and in the prescribed manner, A, be together, correlate, evaluate, and analyze foreign intelligence, excluding foreign military intelligence, in order to, Roman letter 1, identify any opportunity or threat to national security. 2, supply intelligence regarding any such threat opportunity to NCOP. 3, to institute counterintelligence measures within the service. Together, departmental intelligence. 4, together, my apologies, Chair. Number 4 reads as follows. It is amongst the powers of the service would be, in number 4, together, departmental intelligence at the request of any interested department of state and without delay to evaluate and transmit such intelligence and any other intelligence at the disposal of the service and which constitutes departmental intelligence to the department concerned. And 5, to provide periodic national security briefings to the Joint Standing Committee on Intelligence and members of Cabinet. Chair, you note that we removed the reference to the judiciary in this regard, including the reference to the presiding officers, as the JCI is the conduit to the presiding officers. B, and this is by instruction of the committee, Chair. B, by the substitution in section 2 of paragraph B of the following paragraph. 2B, the functions of the agency shall, subject to section 3 and section 2, subsection 2, capital B, and in the prescribed manner, A, B, to fulfill national counterintelligence responsibilities, and for this purpose to conduct and coordinate counterintelligence and together correlate, evaluate, and analyze information regarding counterintelligence and domestic intelligence in order to, Roman letter 1, identify and impede any threat to the security of the Republic and its people. 2, protect members, and in particular those who are exposed to high-risk intelligence operations against threats to personal security, unauthorized disclosure of information, identity, and other acts of hostility aimed at harming members. 3, inform the president of any such threat. 4, supply where necessary relating to any such threat to the South African Police Service for the purpose of investigating any offense or alleged offense. 5, impede and neutralize members suspected of contravention of this act and related regulations and hand them to the relevant law enforcement agencies. 6, supply intelligence relating to any such threat to the Department of Home Affairs for the purpose of fulfillment of any function. 7, supply intelligence relating to any such threat to any other Department of State for the purpose of fulfillment of its departmental functions. 8, supply intelligence relating to national strategic intelligence to NCOP. 9, provide periodic annual security briefings to the Joint Standing Committee on Intelligence, members of Cabinet, premiers, parliamentary presiding officers, and the Chief Justice. 10, Chair, we've noted here that there was an instruction to remove presiding officers in respect of that because the JCI would be the conduit, Chair. But in this respect, Chair, the Chief Justice, I remember, was the decision of the committee was that we keep the Chief Justice and remove the judiciary so that the briefings are to just the head of the judiciary instead of the entire judiciary. Thank you, Chair.
When he read it out, he said, provide annual national security briefings. I don't know if this is periodic. I don't know. That's not necessarily annual. Was that an error in just reading, or is that how it should be?
Chair, I'm required to read as is in the bill, so that if there's any other different instruction to what is written, then we can update it. Where I make comment is where it would not have been properly captured by the service provider who was doing the typesetting. So there, Chair, it should read, provide periodic national security briefings.
Yes.
Thank you.
You said
My apologies. Hey, I'm reading too fast. Sure, sorry. And then number 10, Chair, with your permission to continue. Gather departmental intelligence and at the request of any interested department of state and without delay to evaluate and transmit such intelligence and any other intelligence at the disposal of the agency and which constitute departmental intelligence to the department concerned and to NCOP. 11, conduct security competence test. Chair, that test should be assessment so that we, yes. So it should be assessments in line with the amendment as instructed by committee. On categories of persons or institutions referred to in section 2 capital A of the Act in order to issue or decline to issue a security clearance certificate. And B, by the insertion after section 2 subsection 2 capital A of the following section, 2 capital B, 1. The sender shall, in a prescribed manner and with regard to foreign signals, communications and non-communications, A, gather, correlate, evaluate, and analyze relevant intelligence in order to identify any threat to national security subject to, Roman letter 1, submission of bulk interception application for approval by a retired judge appointed by the president after consultation with the Chief Justice. 2, the sender supplying intelligence to the relevant intelligence structures. Section 2B reads as follows, Chair. In a prescribed manner and with regard to information security and cryptography, the sender shall, Roman letter 1, identify and secure national critical information infrastructures and protect intelligence from unauthorized access, disclosure, technical and related threats. 2, provide verification services for electronic communication security products used by the organs of state. 3, provide and coordinate research and development with regard to electronic communications, products, and any other related services. 4, support secure electronic communication solutions to identified organs of state. And 5, coordinate cybersecurity activities in order to identify and impede any cyber-enabled threats. My apologies. C, when performing any function referred to in section 2 capital B, the sender is exempted from any licensing requirements contemplated in Roman letter 1, the Broadcasting Act of 1999, 2, the Electronic Communications Act of 2005. 2 reads as follows, Chair. The judge appointed in terms of subsection 1 must take due cognizance of, in addition to South African law, applicable international agreements in terms of section 231 of the Constitution and international law, including the Universal Declaration of Human Rights, when considering an application for bulk interception. 3, a bulk interception application must be brought by the sender in the form and manner as prescribed and include A, reasons for the granting of application, B, indicate the period for which the application ought to be granted. Section 2 capital C, Chair, reads as follows. It refers to, it relates to the management of bulk interception data. 1, the procedures to be followed in the processing, examining, copying, sharing, disclosing, sorting through, using, storing or destroying of any data obtained pursuant to and resulting from surveillance in terms of this act. must be in the prescribed manner and on the prescribed conditions. 2, the development of procedures in terms of subsection 1 must take into account principles for the safeguarding of data, including A, accountability, together with conditions for lawful processing, examining, copying, sharing, disclosing, sorting through, using, storing, or destroying. B, processing limitations, including processing in a lawful and reasonable manner, and not processing more data than what is required in respect of the purpose. C, purpose-specific processing of data, including processing for a lawful purpose which is explicit, not retaining data for longer than is necessary in connection with the purpose for which it was obtained, and reviewing compliance with destruction instructions. D, limitation on the use of data for a lawful purpose, including restriction access to data on certain conditions, conditions for sharing and disclosing data, and limitations on the copying of data, including the keeping of relevant records. E, conditions for the storage of data, including the type of data stored and the manner of storage. F, security safeguards, including controlled access to data, processes to prevent unlawful modification and unauthorized disclosure, procedures to identify and foresee any foreseeable internal and external risks, and policies and procedures to safeguard information. And G, where applicable, participation of the data subject through post-surveillance notification. Only instances where it is possible, where applicable. And then 2, capital D, Chair, relates to surveillance arising from bulk interception. 1 reads as follows. If whilst conducting bulk interception, it becomes necessary to engage in surveillance of a citizen of the Republic of South Africa, whether within or outside the Republic, the center must comply with the procedures envisaged in the Regulation of Interception of Communications and Provision of Communications-Related Information Act, 2002, which is RECACHN. 2, the center must notify in writing the person who is subject of the surveillance and, within 15 days of doing so, certify in writing to the designated judge as contemplated in section 15, capital A of RICA, judge of the High Court, Regional Court, magistrate or magistrate that the person has been so notified. If the notification contemplated in the subsection 2 above, Chair, number A, cannot be given without jeopardizing the purpose of surveillance, the designated judge or judge of the High Court, Regional Court, magistrate or magistrate may, upon application by the sender, direct that the giving of notification be withheld for a period which must not exceed 90 days, at a time, or 2 years in aggregate. Or B, has the potential to impact negatively on national security, the designated judge, judge of a High Court, Regional Magistrate Court, or magistrate may, upon application by the center, direct that the giving of notification be withheld for such period as may be determined by the respective judge. That is clause 3, Chair. Thank you.
Members. There's a mover, seconder.
A second. Thank you.
Okay.
Thank you, Chair. We move on to clause 4. Clause 4 is the amendment of section 2, capital A of Act 39 of 1994, as inserted by section 3 of Act 67 of 2002, and amended by section 2 of Act 52 of 2003, and section 3 of Act 11 of 2013. Clause 4 reads as follows, Chair. Section 2, capital A of the National Strategic Intelligence Act of 1994 is hereby amended, A, by the substitution for subsection 1A of the following subsection. 1, the relevant members of national intelligence structures must conduct a vetting investigation in a prescribed manner to determine the security competence of a person if such a person, A, falls within a prescribed category of persons or institutions who must have a security clearance. Roman letter 1, in order to be employed or render a particular service to an organ of state. 2, in order to have access to classified information and intelligence in the possession of that organ of state. Or 3, in order to have access to areas designated as critical infrastructure areas in terms of the relevant law. B, by the substitution for subsection 2 of the following subsection. 2, the agency shall be responsible for conducting security competence assessments of persons contemplated in subsection 1 and, on request of the South African Police Service, the service or the National Defence Force, to persons employed by, applicants or persons rendering a service to the South African Police Service, the service or the Department of Defense and military veterans. That is clause 4, Chair. Thank you.
Any mover, Honorable Stebe, seconded by Honorable Kolabanat.
Thank you, Honorable Chair and members. We move on to clause 5, which is amendment of section 3 of Act 39 of 1994, as substituted by section 3 of Act 37 of 1998, and amended by section 4 of Act 11 of 2013. Clause 5 reads as follows, members and Chair. Section 3 of the National Strategic Intelligence Act of 1994 is hereby amended by the substitution in subsection 1 of for the words paragraph A of the following words. If any law expressly or by implication requires any Department of State other than the agency or the service to perform any function with regard to the security of the Republic or the combating of any threat to national security of the Republic, such law shall be deemed to empower such department to gather departmental intelligence and to evaluate, correlate, and interpret such intelligence for the purpose of discharging such function, provided that such Department of State and B, by the substitution for subsection 5 of the following subsection. 5, notwithstanding any law to the contrary, no Department of State or statutory body, no Department of State or statutory body shall withhold information in its possession or under its control from the agency or service when such information is reasonably required for any investigation in terms of section 2, subsection 1, and subsection 2. Posted. Thank you, Chair. That is clause 5.
Mover, Honorable Lord, seconded by Honorable Stebe.
Did we not add to 5B NCOP, or was that not included? That it must inform.
Chair, the only technical amendment being made, Chair, there was a consequential amendment of agency and service. And we don't recall any addition of NCOP in that section. We would double check, Chair. I don't have that information in front of me now.
Okay, you can continue.
6, Chair. 6, Chair, is an amendment of section 4 of Act 39 of 1994, as substituted by section 4 of Act 37 of 1998, and amended by section 25 of Act 66 of 2000, section 4 of Act 67 of 2002, and section 5 of Act 11 of 2013. 6, Chair, reads as follows, clause 6. Section 4 of the National Strategic Intelligence Act of 1994 is hereby amended, A, by the substitution of subsection 1 for paragraph C of the following paragraph. C, Director of the Service. B, by the deletion of subsection 1D. C, by the substitution for subsection 3 of the following subsection. 3, the Coordinator for Intelligence. A, must, after consultation with the Minister, appoint members or persons who will provide coordination and administrative support to NCOP on such conditions of employment and security requirements as are applicable to members of the intelligence services. B, may determine the organizational structure. Chair, our apologies there because we had instructed us to remove grading of positions because that is a different function, Chair, which resides with the Minister. We will update accordingly, Chair. We've noted it. For functioning of NCOP in terms of the Intelligence Services Act. C, prescribed the manner in which NCOP may co-opt the private security industry regulator as defined in the Private Security Industry Regulator Act of 2001. D, by the insertion after subsection 3 of the following subsection. 4, the budget of the NCOP shall be appropriated by Parliament as part of the budget vote of the intelligence services and shall be expended in accordance with the rules and procedures set out in the Public Finance Management Act of 1999. Thank you, Chair. That is a clause 6.
Any mover? Honorable Kola Barnard, seconded by Honorable Lagude.
Clause 7, Chair. Thank you, Chair. Clause 7 is the amendment of Section 6 of Act 39 of 1994, as substituted by Section 7 of Act 37 of 1998 and amended by Section 26 of Act 66 of 2000, Section 7 of Act 67 of 2002, and Section 7 of Act 11 of 2013. Clause 7 reads as follows. Section 6 of the National Strategic Intelligence Act of 1994 is hereby amended. A. By the substitution in subsection 1 for paragraph A of the following paragraph. Information security and protection of intelligence. B. By the substitution in paragraph 1 for paragraph F, capital D of the following subparagraph. FD. Any matter necessary for the effective execution and administration of counterintelligence functions and to coordination and the coordination and interpretation of intelligence products. C. By the insertion in subsection 1 after paragraph F, capital D of the following subparagraphs. FE. The manner and form in which the operations of the service, the agency, and the center shall be coordinated. F, capital F. The manner and form in which cybersecurity operations shall be conducted and coordinated in the Republic, including the establishment of required technical capacities. F, capital G. The manner and form in which national critical information infrastructure shall be identified, protected, and secured. F, capital H. The manner and form in which policy and legislative compliance monitoring shall be enforced by the minister in the exercise of ministerial control and direction, as envisaged in the Constitution. F, capital I. The manner and form in which the former members of intelligence services shall be structured and utilized within the intelligence services. F, capital J. The code of conduct of former and current members of intelligence services, current and former ministers, and current and former members of parliament with access to intelligence information. And F, capital K. The manner and form in which the intelligence services shall supply post-interception reporting to the judge referred to in section 2, subsection 2, capital B. And D. By the insertion after subsection 1 of the following subsection. 1, capital A. The regulations contemplated in subsection 1A to F, capital K, must be made within 12 months after the commencement of the General Intelligence Laws Amendment Act 2023. Thank you, Chair. That is clause 7.
Any mover? Honorable Kola Barnard, and seconded by Honorable Luat.
Thank you, Chair. Honorable members, we're in clause 8, Chair. It is the amendment of section 1 of Act 40 of 1994, as contemplated in section 1 of Act 31 of 1995, and section 1 of Act 42 of 1999, section 1 of Act 66 of 2002, section 3 of Act 52 of 2003, and section 8 of Act 11 of 2013. Honorable members would recall that the bill that is being amended amends the Intelligence Services Oversight Act over and above the National Strategic Intelligence Act, which we've just completed, Chair. So clause 8 is the first amendment to the Oversight Act. It reads as follows, Chair. Section 1 of the Intelligence Services Oversight Act of 1994 is hereby amended, A, by the insertion before the definition of accounting officer of the following definition. Academy. Academy means the South African National Academy of Intelligence, referred to in Section 5 of Intelligence Services Act of 2002. Yes. B, by the substitution for the definition of agency of the following definition. Agency means the South African Intelligence Agency, referred to in Section 3 of the Intelligence Services Act. C, by the substitution for the definition of head of service of the following definition. Head of service. Head of service means the Director General of the agency or the South African Intelligence Service, the head of the Intelligence Division of the National Defence Force, or the head of the Intelligence Division of the South African Police Service. But for the purposes of financial and administrative accounting, the head of the Intelligence Division of the South African National Defence Force means the Secretary for Defence, and the South African Police Service means the National Commissioner. D, By the insertion after the definition of intelligence of the following definitions. Intelligence services means the South African Intelligence Agency and the South African Intelligence Service as referred to in Section 1 of the Intelligence Services Act of 2002. Intelligence services entities means the academy, the center, and the office. E, the substitution for the definition of office of the following definition. Office. Office means the office of the interception centers established by Section 33 of RICA. F, by the substitution for the definition of services, service of the following definition. Service means the agency, service, the intelligence division of the National Defence Force, and the intelligence division of the South African Police Service. Thank you, Chair. That is clause 8.
Honorable Stebe, moving. Honorable Zagude, seconding.
Apologies, Chair. We are now in clause 9, Chair. The amendment of Section 2 of the Act 40 of 1994 is amended by Section 2 of Act 31 of 1995, Section 2 of Act 42 of 1999, Section 2 of Act 66 of 2002, Section 4 of Act 52 of 2003, and Section 9 of Act 11 of 2013. Clause 9 reads as follows, Chair. Clause 9, subsection 1, subclause 1. Section 2 of the Intelligence Services Oversight Act is hereby amended by the substitution in subsection 1 for paragraph B of the following paragraphs. B, in respect of the administration, financial management and expenditure of the intelligence services entities. B, by the substitution in subsection 3 for paragraph C of the following paragraph. C, the committee shall, within a period of 2 years, after the commencement of the General Intelligence Laws Amendment Act 2023, review the appointment procedures referred to in subsection 2, and C, by the insertion after subsection 8 of the following subsection. 9, no person shall be designated in terms of subsection 8 before the agency has issued a security clearance in the prescribed manner in respect of that person. 2, Section 2 of Act 40 of 1994 is hereby amended by the insertion after chairperson of the following words and deputy chairperson. Chair, I must state at this point that this is amongst the clauses that were originated by the committee chair, which related to making an amendment to provide for a deputy chairperson in the Intelligence Services Oversight Act. Thank you, Chairperson. That is clause 9. Chair, I also just wish to state, Chair, on this, in this regard, my apologies to you and members, that there seems to be as I've mentioned earlier, an editing issue, Chair. So, which is just a numbering issue, consequential numbering issue, which we will fix, Chair, after this process. Thank you.
Mover, Honorable Stebe, seconded.
Chair,
Oh,
the issue of the deputy chairperson is one of those issues which were referred back to the committee for further consultation. Thank you.
the mover with the amendments, Honorable Stebe, seconded by Honorable Zagude.
Chair, we move on to amendment of Section 3 of the Act as amended by Section 1 of the Act 31 of 1995, Section 1 of Act 42 of 1999, Section 3 of Act 52 of 2003, and Section 11 of Act 11 of 2013. This is clause 10, Chair, another amendment of the committee. This one, Chair, relates to where the committee had wanted to add a time or a period for its necessary meeting with the president to discuss matters relating to the Joint Standing Committee on Intelligence. Chair, the only addition that members had said we should do when we are amending this clause, Chair, was to add to meet with the president at least twice a year. And so those were the additions, Chair. So from consult with any members of the cabinet appointed in terms of the constitution, which will include the president, regarding the performance of functions of the committee in terms of this act, that chair is already in the legislation. So the rationale of the committee was to go and make clear that which was implied, make express and clear that which was implied, which were those new additions, Chair. I'm noting this, Chair, because this is one of the amendments, Chair, which have been referred back to the committee in clause 10, Chair. Thank you.
Honorable Stebe,
Clarity. Must we take out the whole section or just the section where we say at least twice a year? I don't know what was the, if Doris can give us a feedback.
was this already in legislation? Meaning that what was inserted here is twice a year. Then it means only twice a year is taken out. That's right. That's my understanding, because it's already there in the legislation. Honorable Stebe?
Chair. Thank you, Chair. I want to have a better understanding of what is it that we are removing. We are removing to meet with the president at least twice a year, because that is one of those that were referred back to the committee for further consultation.
My Honorable Kolabana?
Chair, if we could just read the original that has been altered, then we can see. I thought it was just the twice a year that had been added in. Perhaps it's different.
Honorable Stebe?
Chair, the way I understand it is that we take it to meet with and consult with any member of cabinet. That was previously in the act that we can keep. But that to the president at least twice a year must come out.
Please assist the committee on this. So the
Mike, Honorable Stebe?
Chair, so what is being amended, what the members had proposed to be amended in the original, in the principal legislation, Chair, which was not part of the bill. That is the point of departure, Chair. This is one of those amendments which were not part of the bill as introduced. This is what the committee now had sought the permission of the Assembly to do. It was amendment to the functions of the committee. In section 3K of the Intelligence Services Oversight Act. This clause is already there, Chair. It reads as follows. Functions of the committee in section 3 of the Act. The functions of the committee are, amongst other functions, Chair, we go directly to K. To consult with any member of the cabinet appointed in terms of the Constitution, regarding the performance and functions of the committee in terms of this Act. So in respect of this, Chair, the only addition in the bill by instruction of the committee was to go and add a period, Chair, for this meeting, which was twice a year. And therefore the amendment read to meet with the president at least twice a year end, which was an addition just before what is currently in the legislation, Chair. So if members were removing anything from that section, Chair, for the reasons as stated by members, it would only be the few words before what is already in the Act, Chair, which is to meet with the president at least twice a year end. So that would be removed so that we go back to what the legislation was, Chair, before the committee had proposed the amendment. Thank you, Chair.
Okay. Would we say that because there's cabinet already, and then the president is the head of the cabinet, it's already covered?
Indeed, Chairperson, it is covered because it reads, if I may read again, Chair, to consult with any member of the cabinet appointed in terms of the Constitution. And the president, Chair, is in terms of the Constitution, the head of cabinet, and therefore is covered in that legislation, Chair. Thank you.
Any mover? Honorable Dlagude?
Honorable Chair, I move with the exclusion of the sentence, the first sentence as read. Thank you.
Seconder, Honorable Stebe.
Can I ask something, Chair?
Oh,
I don't have a problem with the motion, but what would consult with any member of cabinet mean? Does it mean cabinet as a whole, or any member of cabinet as and when in their individual capacities? What would that mean? I hear an assumption that the president is already included. Now I'm asking myself, does this sentence really mean that? Because to me, it gives me a connotation of single members in their single capacities.
is that the understanding?
Yes, Chair. Yes, Chair. No, it is true that this says to consult with any member. So it talks about individual members, Chair. And I must state, Chair, that this is in line with Section 92(2) of the Constitution, which says that members of cabinet are individually and collectively accountable to Parliament for the exercise of power and performance of function. So this is simply just to amplify, Chair, that the JCI may want to consult with members of cabinet in respect to matters that relate to their work. I would imagine, Chair, the reason that it is expressly provided there, Chair, it would be my legal opinion, that it covered those ministers who are not ordinarily ministers that would appear before the JCI for the purposes of oversight. This is to give it power to meet any member of cabinet, Chair, whom would be necessary. It even states the reason why the committee should do that, Chair, because it says regarding the performance of the functions of the committee in terms of this act, which is to conduct oversight, Chair. Thank you very much.
I think it's very clear. You okay?
Thank you, Chair. So now we are moving to clause 11, which is, my apologies, which is the amendment of section 6 of Act 40 of 1994, as amended by section 1 of Act 31 of 1995, section 1 of Act 42 of 1999, section 1 of Act 66 of 2002, section 3 of Act 52 of 2003, and section 3 of Act 52 of 2003, and section 8 of Act 11 of 2013. This clause, Chair, reads as follows. Section 6 of the Intelligence Services Oversight Act is hereby amended. 1. The committee shall, within 5 months after its appointment, and thereafter within 8 months after 31 March in each year, table in Parliament a report on the activities of the committee during the preceding year, together with the finding made by it and the recommendation it deems appropriate, and provide a copy thereof to the President and the minister responsible for each service. Chair, this clause, members, just by way of reminder, is the clause where members wanted to make an amendment, a slight technical amendment, to align the reporting chair of the committee with the rest of the reporting in Parliament, Chair. So the period was moved to 2 months, from 2 months to 8 months, Chair. Thank you.
Any mover? Honorable Kola Barnard. Honorable Zagude Seconding.
Chairperson, this is also one of those which were referred back to the committee for further consultation, if I'm not mistaken.
If I was to put my view, we can't remove that one because it's not workable. The way things are, it makes the work of the committee very, very difficult. It means they will have to report a year or 2 years after, which doesn't work out. It's a technical problem. I don't think anybody can have a problem with that one. That's my view.
I hear you, Honorable Chairperson, through you. But if it's part of what was referred back to the committee, so do we defy that resolution of the House? I don't know. I'm just confused. Was this on the original act or is what we inserted as a committee? If I can get a response from that.
The insertion is the 8 months. That's the only thing that, and my understanding is that the 2 months makes it very difficult for the committee to write its reports because department's budget and whatever comes after. So it's just to align that. That's why the reports are, you must get the reports of the departments before we can draft our own report. So now it's not workable the way it is. They will have to report a year or 2 years after. So I don't see any problem with that one, just 8 months. It means that's why we had reports for the previous 2 years, which is just not workable. And I don't think anybody can have a problem with that. That's my view. We need to deliberate on it. That's my view, to make the work of the committee easier because it's not-
Honorable Chairperson,
Oh,
while I understand your response or your inputs to this, and I'm tempted to agree with you. Unfortunately, it was in the report itself. Why can't we remove that 8 months and leave it to the 2 months? Then after consultation, of which I don't believe it will take long in the 7th Parliament, then these insertions can be included in the bill. But for now, I foresee a problem if we can go against the decision of the House. Thank you, Chairperson.
okay. Honorable Kolabana.
Just for clarity, the report was sent back to question what I don't know, to determine what I'm not sure, but for further consultation on what I thought was those 3 issues. Now it's become every single decision by the committee that we changed is now overturned. Is that what is actually happening here? Because I find it very odd. We've allowed some of the stuff has gone through. So has someone highlighted particular changes that we've made somewhere that I don't know about perhaps, or is it in a document, or who's determined which of our decisions are to be overturned and which are not? I'm a bit confused there.
Honorable Chair, can I come in?
Honorable Dagude.
Thank you very much, Honorable Chairperson. What was referred back to the committee are 4 items. 4, not more than that. So that is what was contained in the interim report. So I foresee a problem if we can sit here without consulting anyone and take that decision of including the 8 months. My suggestion is that we keep it to the 2 months, then because we are rising, then in the next Parliament, that will be included in the bill after proper consultation. We cannot ignore the fact that some stakeholders were not consulted, or we didn't consult anyone as this committee, but we took a decision because we understand the issues. There are people who do not serve in this committee and they don't understand the issues. So I don't think this will take any committee 2 weeks to do. It's a 1 week consultation. Thank you, Chair.
Okay, then let's leave it at that. And Honorable Zagude, you were the second. Did we put it?
I second, Chair, with the exclusion of the 8 months. Thank you.
Okay.
Thank you, Chair, and honorable members. We're on page 10, Chair. The amendment of section 12. Sorry, the amendment of section 7 in clause 12, Chair. Section 7 of Act 40 of 1994 is being amended. Is here being amended. A, by the insertion after subsection 1 of the following subsection, 1 capital A, no person shall be appointed as an inspector general without a security clearance issued by the agency in the prescribed manner. B, by the insertion after subsection 2 of the following subsection, 2 capital A, the inspector general shall be appointed for a non-renewable period of 5 years and shall not perform remunerative work outside his or his official duties. C, by the substitution for subsection 5 of the following subsection, 5, the Inspector General who is the subject of an investigation by the committee in terms of subsection 4 may be suspended by the President pending a decision in such investigation. And D, by the substitution for subsection 12 of the following subsection, the Inspector General of Intelligence must, after consultation with the Minister, appoint such member of persons to the office of the Inspector General as may be necessary for the performance of the functions of that office on such conditions of employment as security requirements as are applicable to members of the intelligence services. B, may determine the organizational structure for the function of the Office of the Inspector General in respect of the Intelligence Services Act of 2002. C, the budget of the Inspector General of Intelligence shall be appropriated by Parliament as part of the budget of intelligence services and shall be expanded in accordance with the rules and the procedures set out in the Public Finance Management Act of 1999. 2, Section 7, subsection 7 of the Intelligence Services Oversight Act is hereby amended. C, by the insertion before President of the following words, committee. Chair, this is another amendment of the committee where the committee had wanted to make clear that which is implied in Section 7, subsection 6 of the Oversight Act, which relates to the committee designating the IGI for a particular report, for a special report. And then 3, Chair, so it would have formed part of the interim report that went to the House, Chair. And then subsection, so clause 3, Chair, clause 12, subsection 3, reads as follows. My apologies, Chair, I'm getting confused with the numbering now. Section 7, subsection 11 of the Intelligence Services Oversight Act is hereby amended. E, 1, the committee, after receiving the certificate with the recommendations of the Inspector General of Intelligence, must notify the Minister to submit an implementation plan within 90 days of receipt on how he or she intends to implement the recommendations contained in the certificate of the Inspector General of Intelligence. 2, where the Minister fails to submit to the committee in line with subsection 7, subsection 711E1 of the Act, he or she must submit a written explanation setting up the reasons for non-compliance. Members would remember that this is the section that related to strengthening the recommendations of the Inspector General of Intelligence. So it's also a new edition. 4, Section 7 of Act 40 of 1994 is hereby amended by the insertion of the following subsection. Appointment of the Deputy Inspector General. 7 capital B. The President shall appoint a Deputy Inspector General of Intelligence. A, in the following manner. A, nominated by the committee, and B, approved by the National Assembly by resolution adopted with the supporting vote of majority of the members of the National Assembly. The Deputy Inspector General of Intelligence shall be appointed for such a period as the President may determine at the time of such appointment, but not exceeding 5 years. 2, the Deputy IGI may, at the end of his or her term of office, be reappointed in terms of subsection 1 for 1 additional term. 3, The deputy IGI shall be a South African citizen who is fit and proper, who is a fit and proper person to hold such office and who has knowledge of intelligence. 4, the remuneration and other conditions of employment of the deputy IGI shall be determined by the president with the concurrence of the committee, and such remuneration shall not be reduced, nor shall such conditions be adversely altered during his or her term of office. 5, the deputy IGI shall have such powers as the inspector general may determine to him or her. 6, wherever the IGI is for any reason unable to perform the functions of his or her office, or while the appointment of a person to the office of the IGI is pending, the deputy IGI shall perform such functions. 7, the deputy IGI may be removed from office only on A, the ground of misconduct, incapacity, or incompetence. B, a finding to the effect that by the committee, and C, the adoption of the National Assembly of a resolution calling for his or her removal from office. 8, a resolution of the National Assembly concerning the removal from office of the deputy IGI must be adopted with the supporting vote of a majority of the members of the National Assembly. 9, the president may suspend the deputy IGI in terms of such terms and conditions as the president may determine, including the suspension of the payment of his or remuneration, or the suspension of any other term or condition of his or her employment. 10, if a vacancy occurs in the office of the deputy IGI, the president shall, subject to this section, as soon as possible, appoint another person to that office. Just by way of reminder, members, once again, this is another edition of the committee that related to the practical realities of the IGI not being appointed, or where there is a need for the deputy to act in his position. Thank you, Chair. So it's amongst those clauses that have been referred back to the committee for reconsideration. Thank you, Chair. Clause.
Honorable Kolabana.
I could just have clarity, at the top there, B, 12A, 2A, the Inspector General shall be appointed for a non-renewable period. Now, it currently is renewable for 1 term. And that was put in, and we definitely said it doesn't work, and should it, if not be a 2nd term, then be extended to a 7-year term, as is the practice in other entities. So I don't see what we decided on included there.
Honorable Lagude.
Thank you very much, Honorable Chairperson. I want to agree with our legal advisor here, Mr. Nati, to say that the issue of the appointment of the Deputy Inspector General is one of those issues which were referred back to this committee. Bearing in mind, we had good intention as the committee to have the Deputy Inspector General as a proposal that we need to have this office. Unfortunately, we didn't consult. So hence it is referred back. Our intention was to close that gap of not having the Inspector General for a long period. Unfortunately, it falls within those issues which we were not consulted upon. Then on the issue that my colleague is raising, Honorable Kolabana, of extending the term of the Inspector General to be 7 years, I will definitely differ with her, because the office of the Inspector General, I don't think is one of the Chapter 9 institutions, so we cannot compare that with the Chapter 9 institution. Thank you.
Honorable Stebe.
Thank you, Chair. I just want to know, we put in this deputy IGI, it's on. We put in a deputy IGI for a certain purpose, and that's where when the IGI leave office, we sit with certificates that can't be processed. That was this, and that was by this committee. We saw it fit to bring that in. Now, if we must consult with who must we consult then? I thought that as this committee, we can we can make a sensible case to put it in. I just want to know with whom must we now go and consult? Must we go back to the people or where must we consult? Thank you.
Honorable Zagude.
Honorable Chairperson, while we are a committee of parliament, I don't think we have those powers to create an office because we don't pay for or the remuneration of that office. So I think it is important to note the fact that we recommend to the House for any appointment. If the House agrees, then that will be signed by the President, not us. Hence, it is important to consult the relevant stakeholders before we can take any decision. That is why these issues were referred back to the committee for further consultation. Thank you.
Follow up, Honorable Stebe.
I hear the case for consult. I just want to know with who would we consult this in this matter in future? Is it do we put in a request to Parliament or what do we do? How do we consult in this matter?
Honorable Kola Barnett.
Yeah, Chair, I just want to go back to the point I raised. Currently, in the current bill act, so apologies, the Inspector General may stand because Dr. Dintwe did indeed apply for a second term, as you remember. So for some reason that was changed in the proposed bill put before us. And we had a long debate on this and we said, no, they should be allowed to stand for a second term. There were two options, that or extending it to 7 years. So I think it should remain as it is in the existing bill, as opposed to being altered, cut down to a 5-year term, because as you well know, the first year the person's finding their feet. So we can't, I mean, to continue on with the expertise you've got is very important, or to have that ability if we want it. So I've got a problem with what's being proposed here.
Honorable Stebe.
Chair, I hear what Honorable Barnard is saying, but we are past that. This is what now is currently in front of it. We can't go back and now change it again. That we can't do. And the thing is with I think the 5 years, we can't extend it to 7. We heard why we can't do it. It's not a Chapter 9 institution. And if we want now to say that he must now stand, he can only stand, he can reapply, then we back 5 steps, because already we did this. How come it's in here? Well, it came to this committee. That's how I see it. I might be wrong. Somebody must help me here.
I'm getting confused myself. Nati?
Thank you, Chairperson. Chair, the issue of the term of office is not regulated by the Act as it currently pertains. So the Intelligence of Services Oversight Act, which provides for the appointment of the IG, doesn't provide for the term. That issue is covered in his employment contract, which he signs when he's appointed. This, in terms of the Act, Chair, is provided for in Section 7, subsection 3, which reads as follows. The remuneration and other conditions of employment of the IG shall be determined by the President with the concurrence of the committee, and such remuneration shall not be reduced, nor shall such conditions be adversely altered during his or her office. So this is why, honorable members, in the bill, it is underlined. It's a new insertion. It's not in the legislation. Before this, Chair, the issue of the term of office, the conditions of employment and matters relating to that were regulated by an employment contract, Chair. Thank you.
So
So this is a proposal, Chair, proposed amendment.
can I be given direction now? Honorable Colaban,
Chair, we discussed this at length and we agreed that as it exists now, the IG has the right to apply for a second. It doesn't mean they're going to get in, as the IG did not. But it may be that they do get in and prove to be the best candidate. This insertion stops that. And we disagreed with it at the time. So I think it should just be removed because the employment details of the employment are covered already. So I think that should just be removed because it's not the decision that we took.
okay, we agree, we remove that.
So,
It means it remains as it was.
yes, Chair,
Yes, Chair.
how we would, sorry, Chair to Pagina, I just want to advise members that the effect of the committee's decision now would mean that it is rejected in the bill as proposed. So we will simply omit it, Chair, so that we go back to the status quo in the legislation.
That is the agreement. Any mover? Honorable Colaban, seconder? Nobody wants to second Honorable Colaban? Honorable Dagude?
I second that it remains that we have it on the original bill as it was. We don't add or remove anything. We just leave it as it was. Thank you.
Thank you, Chair. So Chair, just for clarity of instructions on our part, we are omitting the deputy IGI in that clause, and we are omitting the proposed amendment, Chair, which would have given the conditions of service. Thank you, Chair. And then, Chair, the next clause is clause 13, amendment of section 3. It reads as follows: Section 3 of the Intelligence Services Oversight Act 1994 is hereby amended. A, by the substitution in paragraph A1 for item AA of the following item. AA, the financial statements of the services and the intelligence services entities. And B, by the substitution in paragraph A1 for item CC of the following item. CC, any reports issued by the Auditor General on the affairs of the services and the intelligence services entities. C, by the substitution in paragraph A for paragraph 4 of the following subparagraph. 4, the ministers responsible for the services and the intelligence services entities a report regarding the budget for each service or entity for which he or she is responsible. D, by the substitution for paragraph D and E of the following paragraphs respectively. D, to review and make recommendations on regulations under section 6 of the National Strategic Intelligence Act of 1994 and regulations regarding the intelligence functions of the service and counterintelligence functions of the agency, made under section 37 of the Intelligence Services Act of 2002, or section 24 of the South African Police Service Act of 1995. E, to review and make recommendations regarding the interdepartmental cooperation and rationalization and demarcation of functions relating to intelligence and counterintelligence between the agency, the service, the National Defense Force, and the South African Police Service. And E, by the substitution for paragraph L of the following paragraphs. L, to consider and report on the appropriation of revenue for monies for the functions of the services and the intelligence services entities. Thank you, Chair. Clause 13.
Any mover? Honorable Colaban, seconded by Honorable Luate.
Thank you, Chair. Clause 14 is an amendment of Section 4 of the Intelligence Services Oversight Act, which is hereby amended by the substitution in subsection 3 for the words preceding the proviso of the following words. The committee may, for the purposes of functions of its functions, require any minister responsible for service or an intelligence service entity, the head of a service, the director or inspector general to appear before it to give evidence, to produce any document or item, and answer questions put to him or her. And B, by the substitution in subsection 3 for paragraph C of the following paragraph C, have the right to be assisted by members of the services or the relevant intelligence services entities. Thank you, Chair. That's clause 14.
Mover. Honorable Kolabana, seconded, Honorable Zagude.
Thank you, Chair. Clause 15 is an amendment of Section 8. Section 8 of the Intelligence Services Oversight Act of 1994 is hereby amended, A, by the substitution in subsection 1 for the words preceding paragraph A of the following words. 1, the minister acting with the concurrence of the committee must make regulations regarding B, by the substitution in paragraph L for paragraph B of the following paragraph B, the performance of the functions designated to the Inspector General under section 7, subsection 7C, and C, by the insertion after subsection 1 of the following subsection. 1, capital A, the regulations contemplated in subsection 1B to I must be made within 12 months after the commencement of the General Intelligence Laws Amendment Act. Thank you, Chair. That is clause 15.
Honorable Luate, seconded by Honorable Kolabana.
Thank you, Chair. Now we're moving to the amendments of the Intelligence Services Act. Starting from clause 16, section 1 of the Act, as mentioned, Chair, is hereby amended, A, by the insertion before the definition of accounting officer of the following definition. Academy means the South African National Academy of Intelligence referred to in section 5 of this Act. B, by the substitution for definition of agency of the following definition. Agency means the South African Intelligence Agency referred to in section 3 of this Act. C, by the insertion after definition of Auditor General of the following definition. Cyber civilian intelligence structures means the agency, service, and the academy. D, by the substitution for the definition of council of the following definition. Council. Council means the Intelligence Service Council established by section 22. E, by the substitution for definition of former member of the following definition. Former member means any member of the national intelligence structures whose services have been terminated by any person. F, by the insertion after the definition of former member of the following definition. Intelligence services. Intelligence services means the South African Intelligence Agency of the South African Intelligence Service as referred to in section 1 of this Act. G, by the insertion after the definition of security service of the following definition. Service. Service means the South African Intelligence Service referred to in section 3 of this Act. Thank you, Chair. That is clause 16.
Any mover? Honorable Stebe, seconded by Honorable Zagude.
Thank you, Chairperson and members. Amendment of section 2 is in clause 17, reads as follows. So the Intelligence Services Act of 2002 is hereby amended by the substitution for subsection 2 of the following subsection. 2, application of the Act. Unless the context indicates otherwise, this Act applies in respect of all members and former members, irrespective of whether they were members of at the commencement of this Act or whether appointed after the commencement of this Act, and irrespective of whether they work or worked in or outside of the Republic. Thank you, Chair. That's clause 17.
Any mover? Honorable Zagude. Honorable Kolabana.
Is it, and I'm asking the legal expert here, but is it legal to pass something that applies retrospectively? I just found that a bit curious. Is that allowed? It's a peculiar decision. Thank you.
Thank you, Chairperson. Chair, generally in legislation drafting, retrospective application of law is generally not allowed unless there is a specific reason which must be stated in the law why the law must apply retrospectively. It is very rare that you'll find it in legislation, Chair, but there are instances where you will find it. For instance, the duty of care in the National Environmental Management Act has retrospective application to ban those who would have transgressed environmental laws in the past. So there's a specific reason why you do that, Chair. In respect of that proposed clause, Chair, it doesn't say that it's going to bind retrospectively. It's not specific, Chair, in the provision which is proposed. And therefore, Chair, by operation of law, it would only apply prospectively. So the former members who would be bound by this legislation would be those who become former members after the passing of this legislation. Thank you.
Okay. Seconded by Honorable Kolabana.
Thank you, Chairperson and members. The Chair, we're on clause 18. So clause 18 deals with heading of chapter 2 of Act 65 of 2002. It reads as follows: the following heading is hereby substituted for chapter 2 of the Intelligence Services Act of 2002. Establishment, composition and organization of intelligence services, academy and center. Thank you, Chair. That is clause 18.
I see here the academy is the academy, the center is included. There's somewhere where the center is not included. Does it need to be included? I can't remember which paragraph is that. Okay, anyway. Okay, no, there's somewhere where you mentioned the services, but not the center. You mentioned the academy.
I will verify that, Chair.
Is it? Is it not? Okay, okay. I think it's a minor thing anyway. Any mover? Honorable Kolabanat, seconder. Honorable Loate.
Thank you, Chair. We're just noting the editing issues, Chair, which we must update in line with the members of the comments of members, Chair, as we proceed. So on clause 19, Chair, so our apologies for delaying the committee. So on clause 19, Chair, which is an amendment of section 3 of the Intelligence Services Act, it reads as follows. Section 3 of the Intelligence Services Act is hereby amended. A, by the substitution for the heading of the following heading: establishment of agency, service, and center. B, by the substitution in subsection 3 for the words preceding paragraph A of the following words. 1, the South African Intelligence Service and the South African Intelligence Agency are national departments as referred to in Schedule 1 of the Public Service Act, 1994. C, by the deletion of subsection 1, capital A. D, by the substitution for subsection 3 of the following subsection. 3A, the President must appoint a Director General for the service as the head and accounting officer. B, the President must appoint a Director General of the agency as head and accounting officer. And E, by the insertion after subsection 3 of the following subsections. 4, the Director Generals are, the Director General are, so Chair, there is just an issue there of the grammar, are appointed, which should mean Director Generals, the two referred to above, Chair, in D. Directors General, yes, my apologies, Chair. Yes.
It's 100%.
Yes. No, I was correct. Yeah, my English. The Directors General appointed in terms of the Intelligence Services Act of 2002, read together with the Public Service Act of 1994, Proclamation 103 of 1994. 5, there is hereby established a National Communications Center within the agency and shall consist of the head and members seconded from the agency. 6, The head of the center shall be appointed by the minister at a level of the Deputy Director General and perform their functions in terms of this act impartially and without fear, favor, or prejudice. 7, the center shall perform the functions provided for in section 2, subsection 2, capital B of the National Strategic Intelligence Act of 1994. So that is the bulk interception function performed by the center in that section. That's clause 19, Chair. Thank you.
Any mover? Honorable Stebe. Seconded by Honorable Colaban.
Thank you, Chairperson and members. We're moving to clause 20, amendment of section 4 of the Intelligence Services Act. Section 4 of the Intelligence Services Act is hereby amended by the substitution for the heading of the following heading: composition of service, agency, and center. B, by the substitution in subsection 1 for the words preceding paragraph A of the following words: the minister for each of the services and the center. And C, by the substitution in subsection 1 for paragraph B of the following paragraphs. B, create posts, structures, and prescribe functions thereof. Thank you, Chair. That's clause 20.
Any mover? Honorable Dawude. Seconded by Honorable Stebe.
Thank you, Chairperson. Clause 21 in page 14 provides for the amendment of section 5. It reads as follows: substitution of section 5 of Act 65 of 2002, as amended by section 17 of Act 11 of 2013. 21. Section 5 of the Intelligence Services Act of 2002 is hereby amended. A, by the substitution for the heading of the following heading: establishment of the academy. B, by the insertion after the heading of the following subsection: 1, capital A, there is hereby established a South African National Academy of Intelligence as a training academy for intelligence structures. B, the South African National Academy for Intelligence is a branch of the agency, and the head of the academy reports to the Director General of the agency. C, the minister must, in consultation with the president, appoint a head of the academy who is at the level of the Director, Deputy Director General, and acts as executive director and principal of the academy. D, the minister may create posts and structures necessary for the functioning of the academy. C, by the substitution for subsection 2 of the following subsection. 2, it is a new clause, Chair, reads as follows: the academy must, in the prescribed manner and after consultation with the agency and service, A, provide training for members of the national intelligence structures and other government departments, including, Roman letter 1, training to persons in or conduct such examinations or tests as qualifications for the appointment, promotion, or transfer of persons in or to the intelligence services, academy, or departments, as the case may be, as the minister may prescribe. 2, issuing diplomas or certificates to persons who have passed such examinations or tests. And 3, establish and maintaining training institutions or centers in accordance with the applicable laws, or regulations for the training of students or intelligence members. D, by the substitution for subsection 3 of the following subsection. 3, the academy must have a training fund of which the funding consists of: A, all monies which immediately prior to the commencement of this act were monies defrayed for training. B, money appropriated by Parliament from time to time for promoting training under this act. And C, any other money to be utilized for training in terms of this act or from any other source subject to Public Finance Management Act of 1999. E, by the substitution in subsection 4 for paragraph A of the following paragraph. A, the training must be administered by the executive director. F, by the deletion in subsection 4 of paragraph C. G, by the substitution in subsection 5B of the words prescribed preceding item from letter 1 of the following words. B, the executive director must. H, by the insertion after subsection 5C of the following paragraph. D, the executive director must, at the end of each financial year, submit the report to the academy, compiled in accordance of the provisions of the Public Finance Management Act, to the Director General of the agency for consideration. And I, by the substitution for subsection 7 and 8 of the following subsections, respectively. 7, The academy may, in relation to training, cooperate with any institution of higher learning in the Republic or elsewhere to achieve its objectives. 8, the accreditation and recognition of the academy's qualification must be done in accordance with the provisions of the National Qualifications Framework Act of 2008. Thank you, Chair. That is clause 21.
Honorable Kolabana.
Two things, in 21B, 1A, 1D, the minister may create posts and structures. Surely that has to be must, because if she doesn't create those posts and structures, the entity doesn't exist. So I would think that should be must. Please check that. And then in 2, A2, issuing diplomas or certificates to persons, I would say it should be plural, persons who have passed such examination or tests. It should, yeah, diplomas or certificates to persons who have passed such examinations or tests. So 2 S's missing there, according to me.
Okay. 21A, establishment of agency. Shouldn't we say an agency or the agency? No, academy, not agency. And on 21H, the executive director must, at the end of each financial year, submit the report of the academy compiled in accordance with the provision of the Is that any mover? Honorable Kolabana, seconded by Honorable Lagude.
Thank you, Chair. We've noted the grammatical changes that we must update by instruction of members. Chair, we're on clause 22, with the amendment of section 8 of the Intelligence Services Act, which is hereby amended by the substitution of in subsection 1 for paragraph A of the following paragraph. Appoint any person as a member of the Civilian Intelligence Service. Thank you, Chair. That's clause 22.
Any mover? Honorable Kolabana, seconded by Honorable Luate.
Thank you, Chair. Chair, just by with your indulgence, Chair, on the issue of, we've taken the instruction relating to clause 21. There is just that 21D, Chair, which talks about the minister having to create positions and structures which are necessary for the functioning of the academy. Members are saying that we must change that and make it peremptory. We must make it obligatory for the minister to do so. I'm just wanting to take clear instructions with respect of that, Chair, that the discretion is being taken as it's being made now an obligation for the minister to do so, to perform that function.
That was my understanding.
Thank you, Chair. I just want to note it for later updating, Chair. Thank you, Chair. So we are, and members, so we're on 23, amendment of section 9. Section 9 of the Intelligence Structures of the Intelligence Services Act is hereby amended, A, by the substitution for subsection 1 of the following subsection. 1A, there is hereby established a ministerial advisory committee on training, which consists of the head of the academy and the heads of the national intelligence structures or the alternatives. B, the minister may appoint not more than 8 other persons on the basis of necessity and required expertise to serve on the committee. Chair, there's a word missing there, which is to serve on the committee. B, by the substitution for subsection 2 of the following subsection. 2, the persons appointed under subsection 1B may hold office for a renewable period of 3 years, and at least 3 persons appointed must have extensive academic experience and knowledge. And C, by the substitution in subsection 7 for paragraph B of the following paragraph. B, assist the head of the academy to develop a curriculum and to make recommendations to the minister in that regard. Thank you, Chair and members. That's clause 23.
Any mover?
Spotted in 23A, 1A, Ministerial Advisory Committee on Training, which consists, an S is missing there. And you added expertise to serve on the committee. So it's just those two that I can see. Thank you. Then I move.
Any seconder? Honorable Stebe.
Thank you, Chair and members. Chair, we will update accordingly. On clause 24, section 10 of the Intelligence Services Act is being amended, Chair. By A, the substitution of the heading of the following heading, Head of Intelligence Services and Academy. B, by the substitution for subsection 1 and 2 of the following subsections respectively. 1, the Director General concerned or the Executive Director, as the case may be, must, subject to the written directions of the Minister and this Act, exercise command and control of the service, agency, or academy. 2, the Director General concerned or the Executive Director, as the case may be, may, in the prescribed manner and subject to the approval of the Minister and the provisions of this Act, issue functional directives applicable to A, conditions of service and human resources and the Intelligence Services or Academy, as the case may be, provided that such functional directives must be submitted to the Council for consideration. And B, any other matter he or she may deem expedient for the efficient command and control of the Intelligence Service or Academy, as the case may be. C, by the substitution for paragraph 3 for the words preceding paragraph A of the following words, the Director General concerned or the Executive Director, as the case may be, may, in the prescribed manner, subject to the provisions of this Act and in a consultation with the Minister, issue functional directives applicable to D, by the substitution in subsection 3 for paragraph F of the following paragraph. F, any other matter that is necessary for the intelligence and counterintelligence functions of the service and the agency respectively. E, by the substitution for subsection 4 of the following subsection. 4, the Director General concerned or the Executive Director must, as far as reasonably practicable, take steps to ensure that A, national security intelligence, intelligence collection methods, sources of information and identity of members of the intelligence services, center or academy, as the case may be, are protected from unauthorized disclosure. B, neither the intelligence services, center or academy, as the case may be, nor any of its members may, in the performance of their functions, 1, prejudice a political party interest that is legitimate in terms of the Constitution, or 2, further, in a partisan manner, any interest of a political party, or 3, instruct or expect their members to obey a manifestly illegal order. C, the powers of the intelligence services are limited to what is necessary for the purpose of the discharge of its functions in terms of the National Strategic Intelligence Act of 1994, the Secret Services Act of 1978, F, by the substitution in subsection 5 for paragraph A of the following paragraph. A, the Director General concerned or the Executive Director, as the case may be, must at the end of each financial year submit to the Minister a report on the activities of the intelligence services or academy for the relevant financial year that must, 1, include information about any cooperation by the intelligence service or services or academy with an authority of another country in planning or undertaking activities pertaining to the intelligence services or academy's mandate, and 2, except for classified information, be publicly accessible. Thank you, Chair. That is clause 24.
Honorable Kolabana.
Could you just clarify for me in 24.2 and again in C, it has that the DG concerned or executive director may, subject to the approval of the minister and the provisions, issue functional directives. You say it there, and again you say on the next page, may in the prescribed manner, et cetera, surely that's their job. So they must do this. It's not like they have an option of whether to do their job. So I just wondered why you had may there. They do have to issue functional directives. So regarding these conditions of service, et cetera, that's not an optional extra. They have to do that. So I think both of those must be changed to must.
Yes, no, thank you, Chairperson and members. Chair, so the use of may in a provision, Chair, that guarantees a power and which says that in a prescribed manner. So firstly, Chair, I just want to explain that prescribed manner means that in regulations. So this is future regulations that are not there or which still need to be made. So it says that these persons, Chair, or these offices, the DG and the Executive Director, may, as it becomes necessary, because the operational directives, Chair, would be informed. These directives that I refer to would be informed by the needs basis, Chair, because this is creation of policy. So they may exercise that power as it becomes necessary. So that's why, Chair, they are using the discretion there. The power is given, and if it should be necessary, the regulations must be followed in the exercise of that power. Thank you.
Any mover? Honorable Zagude. Second, Honorable Kolabana.
Thank you, Chair. On clause 25, it's the amendment of section 11 of the Intelligence Services Act. It is hereby amended, A, by the substitution in subsection 2 for paragraph A of the following paragraph. A, there is a premises information. There is on any premises information which has or could probably have a bearing on the functions of the intelligence services as contemplated in section 2 of the National Strategic Intelligence Act of 1994, which information is of substantial importance and is necessary for proper discharge of the functions of the intelligence services. B, by the substitution in subsection 2 for the words preceding subparagraph 1 of the following words, he or she may issue the intelligence services with a direction authorizing any member when reasonably necessary. And C, by the substitution in subsection 3 for paragraph B of the following paragraph. B, a direction referred to in paragraph A may be executed by a member of the intelligence services who is authorized to do so by a senior member of the intelligence services holding a post of at least a general manager. Thank you, Chair. That is clause 25.
Mover, Honorable Stebe. Seconded by Honorable Zagude.
Thank you, Chairperson and members. We're on clause 26, which amends section 12 of the Act. It is hereby amended, A, by the substitution for subsection 1 of the following subsection. 1, the minister may, subject to this Act, do or cause to be done all things which are necessary for the efficient superintendence, control, and functioning of the intelligence services, send our academy. B, by the substitution in paragraph 2 of the paragraph. So, Chair, I just want to note that the only change being made from the existing legislation to that is the addition of intelligence service, send our academy, which is underlined. B, by the substitution in subsection 2 for paragraph A of the following paragraph. A, acquire any immovable property with or without any buildings thereon, which is necessary for the efficient functioning of the intelligence services, send our academy, and subject to section 70 of the Public Finance Management Act of 1999, supply guarantees, indemnities, and securities for those purposes. And C, by the substitution in subsection 2 for paragraph C of the following paragraph. C, acquire, hire, or utilize any movable property and any other equipment which may be necessary for the efficient functioning of the intelligence services, send our academy, provided that the utilization of intrusive equipment is as prescribed in accordance with the National Strategic Intelligence Act of 1994. Thank you, Chair. That is clause 26.
Any mover? Honorable Stebe, seconded by Honorable Zagude.
Thank you, Chair. Clause 27 is the amendment of section 13 of the Intelligence Services Act, which is hereby amended by A, by the substitution for subsection 4 of the following subsection. 4, Notwithstanding subsection 1, a member shall have the right to retire from the intelligence services or academy on the date on which he or she attains the age of 60 years or any date after that date. And B, by the insertion after subsection 4 of the following subsection. 5, in a prescribed manner, the minister may determine the role of the former members of the civilian intelligence services. Thank you, Chair. Clause 27.
Mover Loate, Honorable, and seconded by Honorable Zagute. Okay, sure.
Recording stopped.
Okay, there we go. Oh, Nati is not here. Commander-in-Chief.
Recording in progress.
I think the Commander-in-Chief of the session, Nati, you must indicate if you need a break. All right. Can we continue there?
Thank you, Chair. We are on clause 28, amending section 14 of the Intelligence Services Act. It reads as follows, Chair. Section 14 of the Intelligence Services Act is hereby amended A, by the substitution for subsection 1 for paragraph A of the following paragraph. A, information with respect to that person has been gathered in the prescribed manner in a security competence assessment investigation by the intelligence services. B, by the substitution in subsection 2 for the words preceding paragraph A of the following words. 2, in order to gather the information contemplated in subsection 1A, the intelligence services may, in the prescribed manner, have access to. C, by the substitution in subsection 2 for the proviso of the following proviso, provided that where the gathering of the information contemplated in the paragraph C and D requires the interception and monitoring of the communications of such a person, the intelligence services must perform this function in accordance with the RICA. D, the substitution in subsection 4 for the words preceding paragraph A of the following words. 4, the Director General concerned may, in the prescribed manner, issue directives on. E, by the substitution in subsection 5 of the following subsection. 5, the Director General concerned may, after evaluating the information gathered and contemplated in subsection 1B, issue, degrade, withdraw, or refuse to grant a security clearance certificate. F, by the substitution in subsection 7 for the words preceding paragraph A of the following words. If the certificate referred to in subsection 5 is withdrawn, the member concerned is deemed unfit for further membership of the intelligence services, the center or the academy, as the case may be, and the minister may. G, by the substitution in subsection 7 for paragraph A of the following paragraph. A, discharge such person or member from the intelligence services, the center or the academy, as the case may be, or and. H, by the substitution for subsection 8 and 9 of the following subsection, so respectively. 8A, a person whose security clearance has been degraded, withdrawn, or refused by the Director General concerned may, in the prescribed manner, appeal to the minister. B, such appeal must, Roman letter 1, be lodged within 60 days from the date on which the decision was made, known by the Director General concerned, or such later date as the minister may permit, or as the minister permits, and 2, set out the grounds for the appeal. C, after considering the grounds for appeal and the concerned Director General reasons for the decision, the minister must, as soon as practicable, 1, confirm, set aside, or vary the decision, or 2, substitute any other decision for the decision of the Director General concerned. 9, on the intervals prescribed by the minister, a member may be subjected to a vetting investigation to determine his or her statutory competence to remain in the intelligence services, center or academy, as the case may be. So there's just a punctuation issue, Chair, between on the last line, line 40, and the last line between intelligence services and center. Thank you, Chair. That is clause 28.
Honorable Kolabonat.
And please just point it out to me what I'm bearing in mind what we saw happen to the IG under Arthur Fraser, who simply removed his security clearance. What sort of reasons are given for the removal of such or pulling of such a certificate? Is it detailed here? Have I missed it? I'm just scared that it's going to be arbitrary again or a personal, we've had many individuals use things for their own personal ends as opposed to according to strict regulations. Could you just point that out to me, please?
Chair, the issue of issuing of a vetting is a matter that is provided for in the National Strategic Intelligence Act, the Intelligence Services Act, and its regulations. It is not in the bill now, Chair, as introduced. But it exists. There's a procedure for granting. All the bill is saying now is that where a person is aggrieved by that decision, they must appeal to the competent authority, who is the minister, within 60 days of a decision being made by the DG. And the other protection in respect of that issue, honorable members, is that the decision to vet or not to issue a vetting certificate is an administrative action in terms of the PAJA, and therefore is judicially reviewable. So where a person, for instance, was dissatisfied in respect of the decision of the minister, who is the appellate authority in terms of the act, they can take the matter to court to review the decision of the minister. So there is that escalation mechanism in the legislation for administrative action or executive decisions. Thank you, Chair.
Any mover? Honorable Kola Barnard, seconded by Honorable Lagudia.
Thank you, Chair. We're on clause 29. Section 15 is being amended of the Intelligence Services Act by the substitution in subsection 1 for the words preceding paragraph A of the following words. Any member who absents himself or herself, whether voluntarily or involuntarily, from his or her official duties without permission of the Director General or the Executive Director consent, as the case may be, for a period of 15 consecutive days, is deemed to have been discharged from the Intelligence Services Center or Academy, as the case may be, on account of misconduct, with effect from the date immediately following upon the last day on which he or she was present at his or her place of duty, provided that if B, by the substitution in subsection 1 for paragraph B of the following paragraph, B, a member deemed to have been so discharged again reports for duty, the Director General concerned or the Executive Director, as the case may be, may, on good cause shown and notwithstanding anything to the contrary contained in any law, but subject to the approval of the minister, reinstate the member in his or her former post or appoint him or her to any other post in the Intelligence Services Center or Academy, as the case may be, on such conditions as the Director General concerned or the Executive Director, as the case may be, may deem it fit. In that event, the period of his or her absence from his or her official duties is deemed to have been absence of vacation leave without pay or leave on such other conditions as concerned Director General or Executive Director, as the case may be, may determine. And C, by the substitution in subsection 1 for paragraph C of the following paragraph, C, the DG concerned or the Executive Director, as the case may be, refuses to reinstate the member, the latter may appeal to the minister stating the reasons why he or she should be reinstated. Thank you, Chairperson and members. That is clause 29.
29A, whether voluntarily or involuntarily. The involuntarily, what is that supposed to mean? Honorable Kola Barnard.
Yeah, I mean, it immediately struck me, what if it's an injury? If a person's hit by a car, is unconscious in a hospital for 10 days, are they going to be thrown out? Is that covered somewhere? Because it's not covered here. And I think that would refer to the involuntarily absent, but why would you be fired for being in a terrible accident and somehow incapacitated, stroke, whatever? So if we could just get some feedback on that, please.
Thank you, Chairperson. Chair, I just first want to state that that clause is what is in the legislation currently. All that is amended there is the addition which is there is underlined, which is the executive director concerned, as the case may be, as well as the period of 15 days instead of 10 days, including the issue of the services center and academy, which is consequential to the separation, Chair. Otherwise, that section is already there. So that's the first thing I wanted to mention, Chair. The second thing is that this is a deemed abscondence of a person who absents themselves from work. So if you are absent for 15 days, you are deemed to have discharged yourself. Until you can come back to provide a valid reason, Chair, as to where as to your whereabouts in that period. Because if you look at the very next one, sir, it says a member deemed to have been also discharged again reports for duty. The DG concerned may on good cause show, meaning when the person now brings reasonable and valid legal reasons of their absence, then the DG has the discretion, Chair, to then take that person back into the service or appoint that person to a different position. So this is what the law currently pertains to, with those changes I've identified. And I've just sought to try and explain what that section is about. It's about absconding and where you present yourself after the day stated there, which used to be 10 days, but now 15 days. You would then have to rely on the discretion of the DG, would either take you back on good cause show or redeploy you to a different position. Thank you, Chair.
Honorable Stebe, followed by Honorable Kolaban.
Chair, I think if you see contrary contained in any law, that can be any other law. So if a person is in an accident and you don't know about him and he's in the hospital for 20 days, that any other law, I think that will be suffice to make a decision and not to just summarily get rid of a person, because that will be in the Labor Act. So I think it's fairly covered. Thank you.
I just wanted, for interest's sake, why it was changed from 10 days to 15. Is that pulling it in line with other labor legislation, perhaps?
See?
So where Chair, the department explains in the memorandum why the changes are being made. The explanation there is that clause 15 outlines the application of the Intelligence Services Act, and the bill extends the application to include former members. No, this is not clause 15, this is clause 29, Chair. So I must go to clause 29 in the memo. Chair, there is no, it's not there. It's not there, Chair. So I'm assuming, Chair, the reason it's not in the memo is because the additions from the legislation are simply consequential to the changes of separation, Chair, between the two. Otherwise, that is currently in the legislation. It's a matter that members can, and it's would be within their rights to debate, Chair, if they wanted a possible change to that.
Is it Honorable Loate?
Yeah, Chair, isn't it that in the labor law, it's 30 days of continuous absence? Yeah. It's 30. It's 30 days, and then there are, well, I mean, legal people can check, but my recollection says it's 30 days, and there are certain steps that the institution also is expected to take to ascertain why the person is absent continuously.
So in the Principal Act, it's saying 10 days.
Just to mention, is that regime that is set by this section is different from that which is in the Labor Relations Act as it applies to everyone. Chair, because where it says notwithstanding anything to the contrary contained in any other law, but subject to the approval of the minister. So even if any other law except for this law provided for different regime, this law would stand. Chair. So that's the effect of those words. So the term and the conditions for absconding and persons being taken back into the service, including be redeployed, would be done in terms of what is provided for in that clause. And no other law.
Okay. So is it because it's a different environment altogether? Okay. Any mover? Honorable Stebe? No one supports the Honorable Stebe? Oh. Honorable Zagude.
Thank you, Chair. We're moving to clause 30, amendment of section 16 of the Intelligence Services Act, which is hereby amended A, by the substitution for subsection 1 of the following subsection. 1, any member may be discharged from the Intelligence Services Center or Academy as the case may be by the DG concerned or the Executive Director as the case may be, if after a hearing is in the prescribed manner and to his or her state of health, such Director General or Executive Director as the case may be, is of the opinion that the member is by reasons of his health unfit to remain in the Intelligence Services Center or Academy as the case may be. So that's the issue of medical boarding chain. B, by the substitution for subsection 2 of the following subsection 2, any member discharged from the Intelligence Service Center or Academy in terms of subsection 1 may in the prescribed manner appeal to the minister who may thereupon set aside or confirm his or her discharge. Thank you, Chair. That's clause 30.
Any mover? Honorable Zagude, seconded by Honorable Lord.
Thank you, Chair. Clause 31, section 17 of the Intelligence Services Act is hereby being amended. A, by the substitution for subsection 1 of the following subsection. 1, any member may be discharged from the Intelligence Services Center or Academy or demoted by the DG concerned or the Executive Director as the case may be, if after a hearing in the prescribed manner as to his or her fitness to remain in the employment or to retain his or her rank or grade, such DG or Executive Director as the case may be, is of the opinion that such member is incapable of performing his or her duties efficiently. And B, by the substitution for subsection 2 of the following subsection. 2, a member who has been discharged from the civilian intelligence services or demoted in terms of subsection 1 may in the prescribed manner appeal to the minister who may thereupon set aside or confirm his or her discharge or demotion as the case may be. Thank you, Chair. That's clause 31.
Did I hear you saying demoted or what? I don't see it here.
Stay, Chair, in line 47. It says, a member who has been discharged from the civilian intelligence service, which is the only addition, or demoted in terms of subsection 1, may in the prescribed manner appeal to the minister, who may thereupon set aside or confirm his or her discharge or demotion as the case may be.
Okay, no, I was looking at clause 13 myself. Okay. Any mover? Honorable Zagude, seconded by Honorable Stebe.
Chair, the next clause is clause 32, which is the amendment of section 18 of the Intelligence Services Act, which is hereby amended by the substitution for subsections 2 and 3 of the following subsections respectively. 2, a member may be discharged from the civilian intelligence service or demoted by the DG concerned or the executive director, as the case may be, if after a hearing in the prescribed manner as to his or her fitness to remain in employment or to retain his or her rank, grade, such director general or the executive director, as the case may be, is of the opinion that such a member is guilty of misconduct. 3, a member who has been discharged from the civilian intelligence service or demoted in terms of subsection 2 may in the prescribed manner appeal to the minister, who may thereupon set aside or confirm his or her discharge or demotion, as the case may be. Thank you, Chair. Clause 32.
Any more, Honorable Luate, seconded by Honorable Kolabanat.
Thank you, Chair. and members.
It has been very quiet on the platform. Members, if you want to hop in anytime. Okay.
On clause 33, Chair and honorable members. We are amending the bill amends section 19 of the Act, Intelligence Services Act. It is hereby amended, A, by the substitution in subsection 1A for paragraph 1 of the following subparagraph. Roman letter 1, in the civilian intelligence service. B, by the substitution in subsection 1A for item CC of the proviso of the following item. CC, a member may not without his or her consent be transferred to a post outside the civilian intelligence service. If such transfer will save for his or her salary, result in a charge in his or her conditions of service. B, C, by the substitution in subsection 1 for paragraph B of the following paragraph. B, discharge any member from the civilian intelligence service on conditions as the minister may determine. And D, by the substitution for subsection 2 of the following subsection 2, the minister may, with the consent of a member and upon such conditions as the member may determine, second a member for the performance of a particular service or for a specified period to the service or to the service of any other department, intelligence service, academy, or to any other authority, board, entity, establishment, institution or body, but while so concerned, was so seconded, the member remains subject to this act and any other law which applies to him or her. Clause 33.
Honorable Kolabanat, supported by Honorable Luat.
On clause 34, amendment of section 20 of the Intelligence Services Act, it is hereby amended, A, by the substitution for subsection 1 of the following subsection. 1, the minister may in writing and on such conditions as may deem fit delegate any power conferred upon or duty assigned to him or her by this act, excluding any power conferred upon or duty assigned to him or her by subsection 4, subsection 1A and B, 5, subsection 1, 2A and 4C, 9, subsection 3, 4, 5, 8 and 9, 10, subsection 1, 2 and 3, 12, subsection 1 and 2A and B, 13, subsection 3, 14, subsection 6, 7, 8, 9 and 11, 15, B and C, 16, subsection 2, 17, subsection 2, 18, subsection 3, 19, subsection 4, 21, subsection 2, 22, subsection 1, 5 and 7, 23, subsection 3A, Roman letter 1 and 2, 28, subsection 2, 30 and 37, to the Director General concerned, or Executive Director, or any other member of the intelligence services or academy as the case may be. And B, by the substitution for subsection 2 of the following subsection 2, A DG or executive director may delegate any power conferred upon or duty assigned to him or her by or under this act to any other member of the intelligence service or academy, as the case may be, but not any power or duty delegated under subsection 1. Thank you, Chair. That's clause 34.
Honorable Stebe, Honorable Kola Banat.
Thank you, Chair. Clause 35. Amendment of section 21. Section 21 of the Intelligence Services Act is hereby amended by the substitution for subsection 1 and 2 of the following subsections respectively. 1. No member of the Civilian Intelligence Service may strike or induce or conspire with any other member or person to strike. 2. The minister must, in the prescribed manner, make provision for the internal rules to deal with complaints, grievances, and consultation on conditions of service and human resources within the Civilian Intelligence Service. Thank you, Chair. Clause 35.
Mover, Honorable Stebe, supported by Honorable Lagude.
Clause 36, Chair, is an amendment of section 22. Section 22 of the Intelligence Services Act is hereby amended. A, by the substitution for the heading of the following heading: Establishment of Intelligence Service Council. B, by the substitution for subsection 1 of the following subsection. 1. There is hereby established an Intelligence Services Council, which consists of not more than 3 persons appointed by the minister, one of whom must be the chairperson. C, by the insertion after subsection 2 of the following subsections. 2, capital A member of the council, A, holds office for a period not exceeding 5 years, and B, may, in the interest of continuity, be reappointed, but may not serve more than 2 consecutive terms. 2, capital B, a person may not be appointed as a member of the council before the agency has issued a security clearance in the prescribed manner in respect of that person. 2, capital C, the minister may remove a member of the council from office on account of misconduct, incapacity, incompetence, withdrawal of his or her security clearance, or absence from 3 consecutive meetings of the council without the prior permission of the chairperson, except on good cause shown. D, by the substitution in subsection 3 for paragraph B, capital A of the following paragraph. B, capital A, to promote measures and set standards to ensure the effective and efficient performance and implementation of policies and human resources within the intelligence services or academy, as the case may be, and to make recommendations to the minister. E, by the substitution in subsection 3C for item 4 of the following item. 4, Roman letter 4, to invite the Director General, Executive Director, the Chairperson of the Staff Forum, members, and any other interested party to give representations on any matter relating to the purview of its functions. F, by the substitution for subsection 4 of the following subsection. 4, the chairperson may co-opt a Director General or Executive Director to participate in the function of the council, provided that such Director General or Executive Director does not have voting powers. And G, by the substitution for subsection 5 of the following subsection. The conditions of service of members of the council may be determined by the minister in accordance with the conditions of service as security requirements applicable to members. Thank you, Chair. Clause 36.
Honorable Kola Banat.
Chair, does it not seem a bit counterintuitive to you that a body that is representing the workers, as it were, is appointed by the minister? In other words, the staff have zero input into who will represent them in terms of the conditions of employment. It seems a very disconnected way to do things. And in terms of labor legislation, I'm sure it's backwards. I don't see why the minister would be involved at all. These are the representatives of the staff. Why would those persons be appointed by the minister? Perhaps someone can explain that to me.
No, I think this is a different body altogether. It's not the staff council. This is something else. And it's very interesting that for such a very long time, we didn't even know it exists. So this is a different one altogether. That's why they're talking about 3 people, not more than 3. Mhm. That's right. It's not the staff council. Well, Honorable Stebe, seconded by Honorable Dagute.
Chair, we move to clause 37, amending section 23 of the Act, Intelligence Services Act, which is hereby amended by substitution for subsection 3 of the following subsection. 3A, where a member receives any remuneration, allowance, or other reward in connection with the performance of his or her function, work, otherwise done in accordance with this Act, or in contravention of subsection 1B, such member must pay the intelligence services, send or academy, as the case may be, an amount equal to the amount of such remuneration, allowance, or reward, where it does not consist of money, the value thereof is determined by the concerned Director General or the Executive Director, as the case may be, and if he or she does not, such Director General or Executive Director may recover it from him or her by way of legal proceedings, provided that, 1, the member has a right to appeal to the minister against the determination by the DG or the Executive Director of the value of the remuneration, allowance, or reward, and 2, the minister may approve the retaining by a member of the whole or portion of that remuneration, allowance, or reward. B, where a member has received any remuneration, allowance, or other reward as contemplated in paragraph A, which is still in his or her possession or under his or her control, or in the position or under the control of some other person on his or her behalf, or if it is money, if or her name, or in the name of some other person, or in his or her behalf, the DG or Executive Director concerned, as the case may be, may in writing require such member or such other person or such bank or financial institution not to dispose thereof. Or, if it is money, to retain a corresponding sum of money, as the case may be, pending the outcome of any legal proceedings for the recovery of such remuneration, allowance, or reward, or value thereof. Thank you, Chair. Clause 37.
Any mover? Honorable Zagude, supported by Honorable Stebe.
Thank you, Chair. Clause 36, amendment of section 24.
Did you
Section
say
24.
36?
No, it's clause 38, my Chair.
That's right.
Yeah, members and chairperson. We're on clause 38. We're amending section 24 in terms of the bill. Section 24 of the Intelligence Services Act is hereby amended by the substitution for subsection 24 of the following section. The DG or Executive Director concerned, as the case may be, may, with the approval of the minister, award to any person who is or was a member for extraordinary diligence or devotion in the performance of his or her duties as a member, such monetary or other reward as he or she considers appropriate in the circumstances. Thank you, Chair. Clause 38.
Honorable Kolabanat. Honorable Luati.
Thank you, Chair. Clause 39. Amending section 25 of the Intelligence Services Act. It is hereby amended by substitution for subsection 1 of the following subsection. 1. The minister may establish and introduce decorations and medals, as well as bars, clasps, and ribbons, in respect of such decorations and medals, which may be awarded by him or her, subject to such conditions as may be prescribed, to any person who is or was a member in respect of his or her services as a member, or to any other person who has rendered exceptional service to the civilian intelligence services. Thank you, Chair. Clause 39.
On a lighter note, where do they put these medals? Moved by Honorable Zagude, supported by Honorable Kolabana.
Thank you, Chair and members. We're still on page 22, we're in clause 40. Amendment of section 26 of the Intelligence Services Act. It is hereby amended A by the substitution in subsection 1A for subparagraph Roman letter 3 of the following subparagraph. Roman letter 3 discloses classified information or material entrusted to him or her by the DG consent or executive director or a member without permission of the DG consent or executive director, as the case may be. B, by the substitution in subsection 1 for paragraph C and D of the following paragraphs, respectively. C, not being the person to whom a decoration or medal was awarded, wears it or, without the written permission of the DG consent or executive director, as the case may be, makes use of any decoration or medal established or introduced under this act, or of its bar, clasps, or ribbon, or anything so closely resembling any such decoration, medal, bar, clasp, or ribbon as to be calculated to deceive. D, without the approval of the minister, in connection with any activity carried on by him or her, takes, assumes, uses, or in any manner publishes any name, description, title, or symbol that indicates or conveys or purports to indicate, or which is likely to lead other persons to believe or infer that such activity is carried on under by virtue of this act or under the patronage of the intelligence services, center or academy, or is in any manner associated or connected with the civilian intelligence service. C, by the substitution in subsection 1F for paragraph I of the following subparagraph. For paragraph Roman letter 1 of the following paragraph, subparagraph. Roman letter 1 discloses classified information or material without the permission of the DG, consent or executive director. D, by the substitution in subsection 1 for paragraph G of the following paragraph. G, being a member, discloses classified information or material to an unauthorized person without the permission of the DG of the agency. Thank you, Chair. That's clause 40.
Any mover? Honorable Luate, supported by Honorable Zagude.
Thank you, Chair. I'm on clause 41. Section 27 of the...
Maybe before we continue, the very last line 15, permission of the Director General of the agency. Does that exclude the service?
I've only added, Chair, in the proposed bill, the agency. So in line as a consequential amendment, Chair. But it appears, Chair, that this is a domestic function because throughout that amendment, it talks about the agency and doesn't mention this, or it does add the service, Chair. You're correct, Chair. So we've noted that we would have to do the consequential amendment, Chair, to reflect the separation in respect of that in clause 15, Chair. Thank you for that. In clause 41, Chair, in page 23, the committee is amending section 27 of the Intelligence Services Act there, which is hereby amended by the substitution for subsection 1, 2, and 3 of the following subsections respectively. 1, subject to section 10, subsection 3A, a former member may not disclose in any form or any manner any information or material to any other person unless the Director General or the Executive Director consent, as the case may be, has granted permission for the disclosure of such information or material. 2. Subsection 1 applies to any information or material received by the former member during or subsequent to the former member's employment or other service with the Civilian Intelligence Service or with the former National Intelligence Agency, the South African Secret Service, the South African National Academy, and the Intelligence or the State Security Agency that was marked as classified or that the former member knew or ought reasonably to have known was classified. 3. For the purposes of subsection 1, the DG or the Executive Director concerned may consult any member or person to advise him or her on the considerations of applications by former members for permission to disclose classified information or material. Thank you, Chair. That is clause 41.
Any mover? Honorable Stebe, supported by Honorable Kolaban.
Clause 42, Chair. Amendment of Section 28. Section 28 of the Intelligence Services Act is hereby amended by the substitution for subsection 1 of the following subsection. 1. A former member may not, for a period of 3 years after leaving the Civilian Intelligence Service or the former State Security Agency, render a security service unless he or she has obtained a clearance certificate from the DG or of the agency. Thank you, Chair.
Clearance certificate. Does that mean vetting?
It appears, Chair, this is some kind of restraint of trade for members of the services that they may not render similar services unless so granted by the DG of the agency, Chair.
Any mover? Honorable Kolaban, supported by Honorable Stebe.
Thank you, Chair. Clause 43, amendment of Section 29. Clause 43, Section 29 of the Intelligence Services Act is hereby amended by the substitution for paragraph A and B of the following paragraphs, respectively. A, who is or was a member, representative or associate of the Civilian Intelligence Service or the former National Intelligence Agency, the South African Secret Service, the South African National Academy of Intelligence, the State Security Agency, or a foreign intelligence service. B, who cooperates or has cooperated with the Civilian Intelligence Service or with the former National Intelligence Agency, the South African Secret Service, or the South African National Academy, or Intelligence, or the State Security Agency, in respect of matters concerning security of the Republic. Thank you, Chair. That is clause 43.
Any more? Honorable Zagude, Honorable Luate.
Thank you, Chair. Clause 44. Section 30 of the Intelligence Services Act of 2002 is hereby amended by the substitution for subsection 1 of the following subsection. 1. A former member may appeal to the minister against a decision of the Director General or the Executive Director concerned in terms of Section 27, subsection 1 or 28, subsection 1. Thank you, Chair. Clause 44.
Any mover? Honorable Kolaban, followed by Honorable Luate.
Thank you, Chair. Clause 45. Amendment of Section 33. Section 33 of the Intelligence Services Act 2002 is hereby amended by the substitution for subsection 1 of the following subsection. 1. The minister may, by notice in the Gazette and in any other appropriate manner, prohibit or restrict access to any premises under the control of the Civilian Intelligence Services. Thank you, Chair. Clause 45.
Mover? Honorable Stepe, supported by Honorable Zagude.
Thank you, Chair. Clause 46, which also appears to be a consequential amendment. It reads, Section 34 of the Intelligence Services Act is hereby amended to A, by the substitution for subsection 1 of the following subsection. 1. Notwithstanding anything to the contrary contained in any other law, the minister may establish canteens, for the civilian intelligence services and for the organizational components thereof, and B, by the substitution for subsection 3 of the following subsection. 3. For the purpose of this section, canteen includes any mess, pub, or institution of the intelligence services, or the academy, as the case may be, or any premises temporarily or permanently used for providing recreation, refreshments, or necessities, mainly for members or retired members, or for the families of such members or retired members, or for persons employed in any work or any work in or in connection with any such mass, pub, institution, or premises. Thank you, Chair. That is clause 46.
Honorable Kolabanat, Honorable Zagude.
Chair, we're on clause 47. In this clause, Chair, it amends section 35. The Act is hereby amended, Intelligence Services Act, A, by the substitution for subsection 1 of the following subsection. 1. If a member is missing and the DG or executive director concerned, as the case may be, is satisfied that his or her absence arose from the performance of his or her functions in terms of this Act, such members shall, for all purposes, be deemed to be still employed by the intelligence services or academy, as the case may be, until the day on which he or she again reports for duty, or until the day on which a competent court issues an order whereby the death of such member is presumed. And B, by the substitution for subsection 4 of the following subsection. 4. Notwithstanding subsection 2, the DG concerned or the executive director may, in the prescribed manner, direct that only a portion of the salary or wages and allowances of a member be paid, or that no portion thereof be so paid. Thank you, Chair. 47.
Honorable Stebe, supported by Honorable Zagude.
48, Chair, amend section 36 of the Act, Intelligence Services Act, is hereby amended by the substitution for subsection 1 of the following subsection. 1. The minister may, in the event of war or when a state of emergency exists and having regard to the requirements of the civilian intelligence services, second, any member for service or training in the South African National Defence Force or the South African Police Service. Thank you, Chair. Clause 48.
Honorable Stebe, Honorable Kolabana.
Thank you, Chair. Clause 49. Amendment of section 37. As substituted by section 16 of Act 52 of 2003 and section 48 of Act 11 of 2013. Section 37 is hereby amended by the substitution in subsection 1 for paragraph D of the following paragraph. D. The numerical establishment of the intelligence services and academy, the conditions of service of the members thereof, the salaries, salary scales, wages, and allowances of members and the systems relating to the administration and determination thereof, and the various divisions, branches, grades, ranks, and designations in the civilian intelligence service. B. By the substitution in subsection 1 for paragraph F of the following paragraph. F. All matters relating to discipline, command, and control of members of the civilian intelligence services, the suspension of members and the establishment of boards of inquiry into the conduct and discipline of members. C. By the insertion in subsection 1 after paragraph J of the following paragraph. J capital A, subject to the Public Service Act of 1994 and any other applicable laws, the conditions of service of the Director General after consultation with the Minister of the Public Service and Administration. D. By the substitution in subsection 1 for paragraph L and M of the following paragraphs respectively. L. The retention of rank on retirement or resignation from the Civilian Intelligence Service and the award of honorary ranks. M. The control over the administration of funds appropriated to the Civilian Intelligence Service in order to bring about the systematic and orderly management thereof and to promote efficiency and economy in the utilization thereof. E. By the substitution in subsection 1 for paragraph O and P of the following paragraphs. O. the conditions for and procedures regarding the permission of access to any premises under the control of the civilian intelligence services and matters related thereto. P, any matter relating to the information, communications, computer and physical security and the civilian intelligence services. F, by the substitution in subsection 1 for paragraph S of the following paragraph. S, vetting investigations of members and persons to be employed in the civilian intelligence services. G, by the substitution in subsection L for paragraph S capital A of the following paragraphs. S capital A, the structure and role of former members of the civilian intelligence services. And H, by the substitution in subsection 1 for paragraph S capital E of the following paragraph. S capital E, persons authorized to task the intelligence services to gather and produce intelligence. And S capital F, role of the former members of the civilian intelligence service. Thank you, Chair. That is clause 49.
Any mover? Honorable Zagude, supported by Honorable Stebe.
Thank you, Chair. Clause 50, page 26, amendment of section 38. Section 38 of the Intelligence Services Act is hereby amended. A, by the substitution for subsection 1 of the following subsections. 1, the rights in respect of all discoveries and inventions and all improvements in respect of processes, apparatus, and machinery made by a member resulting from research undertaken by such member in the course of his or her employment as a member vest in the intelligence services or academy as the case may be. And B, by the substitution for subsections 3 and 4 of the following subsections respectively. 3, if the rights in respect of any discovery, invention, or improvement vest in the intelligence services or academy in terms of subsection 1, the minister may award to the person responsible for the discovery, invention, or improvement such bonus as he or she deems fit, or make provision for financial participation by such person in the profits derived from the discovery, invention, or improvement, to such extent as the minister may determine with the concurrence of the Minister of Finance. 4, the minister may apply for a patent in the name of the Intelligence Service or Academy in respect of any discovery, invention, or improvement referred to in subsection 1, and the Intelligence Service or Academy must, for the purposes of Patents Act, be regarded as the assignee of the discoverer or inventor concerned. Thank you, Chair. Clause 50.
Honorable Stebe. Honorable Luate.
Thank you, Chair. Clause 51. We're still in page 26 and amending section 40, Chair. Section 40 of the Intelligence Services Act is hereby amended. A, by the substitution for subsection 2 of the following subsection. 2, all assets, liabilities, rights and duties, including funds, resources, and administrative records of the former State Security Agency must be transferred in accordance with the provision of the Public Finance Management Act of 1999 to the South African Intelligence South African Intelligence Agency, South African Intelligence Service, SENDA, and the South African National Academy of Intelligence within 24 months after the commencement of the General Intelligence Laws Amendment Act of 2022, and must vest from the date of transference in and must from that date be regarded as having been acquired or incurred by the South African Intelligence Agency, South African Intelligence Service, SENDA, and the South African National Academy of Intelligence, as the case may be. B, by the substitution in subsection 4 for paragraph A of the following paragraph. A register of deeds must, upon the production to him or her of a certificate by the minister that immovable property described in the certificate vests in the South African Intelligence Agency, South African Intelligence Service, SENDA, and the South African National Academy of Intelligence, as the case may be, in terms of subsection 2, make such entries and endorsements as he or she may determine necessary in or on any relevant register, title deed, or other document in his or her office, so as to give effect to subsection 2. C, by the substitution for subsection 5 and 6 of the following subsections respectively. 5, if an inquiry into an alleged misconduct has been instituted by an entity referred to in subsection 2, but not yet included at the commencement of the General Intelligence Laws Amendment Act 2023, such proceedings must be continued and concluded in accordance with the law in terms of which the inquiry was instituted. 6, disciplinary proceedings may be instituted and concluded in terms of this act against alleged improper conduct of any person who at any time prior to the commencement of this General Laws Intelligence Laws Amendment Act 2023. So Chair will just have to make sure that we correct that it's either 2023 or 2022 for consistency. Was in the service of the intelligence structure or any entity referred to in subsection 2, provided that the act of omission concerned is substantially the same as an act constituting misconduct in terms of this act. And D, by the insertion after subsection 9 of the following subsections. 10, any regulation in terms issued in terms of subsection 37 of the Intelligence Services Act 2002 shall remain in force for a period of 12 months after the date of commencement of the General Intelligence Laws Amendment Act 2023, unless it is inconsistent with this act. 11, any recommendation, any memorandum of understanding or agreement entered into by or on behalf of the former State Security Agency will remain in force after the date of commencement of General Intelligence Laws Amendment Act 2023 to the extent that they remain applicable. Thank you, Chair. That's close to 51.
Chair.
Question, Honorable Kolabana, do you want to follow?
Yes, thanks, Chair. I just, am I correct that the new regulations, we gave a period of 12 months. So that then makes sense that this stays in effect for the 12 months during which time. But what if those regulations are finished in 10 months? Is that catered for? In other words, can they then legally scrap the former regulations, or do they have to specifically wait for the 12 months?
Honorable Stebe?
Chair, just there on page 26, line 40. Amendment Act 2022, shouldn't that be 2023?
Line 38, where there's a change within 6, change to 24 months. Is that the transfer of assets, liabilities, and so on? Why the 24? Doesn't it give somebody a chance to hide some of these things in the 24 months? Why is it not automatically transferred? Very difficult to understand. Why 24 months?
Chair, in the
It
explanation.
gives somebody a chance to hide the safe houses and the cars and in 24 months. What's your opinion in relation? I'm not sure whether you're the right person to answer that question. Why increase the 6 months? Eh? Why can't it be 3 months? Why can't it be automatic? Honorable Stebe?
Chair, I think this got to do with, we must remember now there's going to be 2 services. So there's shared stuff that they must unbundle. And then it must be, and that might be, they deem that 24 months is, you don't, what is it? Yeah, 24 months is for them. But I agree it's too long. And maybe if it was 6 months, because the 6 months came from somewhere, maybe we should keep it 6.
And Nati?
No, thank you, Chairperson. So, Chair, the purpose of that clause in legislation, firstly, the clause is known as a transitional arrangement, moving from this regime to what is now the new regime, Chair, of the services. So it's to allow the period of handing over of all of the things that are mentioned there, assets, liabilities, and so forth, Chair. So there is a whole process of doing this, Chair, which would include firstly developing the inventory of all of the properties and all of the things that need to be transferred and where they need to be transferred to. So that is a rationale, Chair. What I have not empowered to respond to, Chair, is why it would take 24 months instead of 6. I will only offer this as advice, Chair, that in the legislation currently, which appears to be removed now by this clause, it is supposed to be done within 6 months. But now it's proposed that it must be done in 24 months, Chair. Thank you.
It within our rights to remain at 6 months.
It is, Chair.
I can see all the heads are nodding. Okay.
And Chair, if the 6 months was not practicable, there would be a mechanism to request a condonation of non-compliance with that time period, Chair. Thank you.
Honorable Stebe?
Chair, I think the 6 months is sensible. If you make it 24 months, maybe then they can say, but we can't have 2 services before this is done. So in a way, in 6 months, you force them to do the job so that they can function as 2 separate services.
Any mover with the amendment, Honorable Kolabanant, followed by Honorable Loate.
Thank you, Chair.
I wonder how I picked that one up.
Honorable Chair, we're on page 27. And I'm happy to say, Chair, that we are on the last, second last clause, which is clause 52 of the bill. That one, Chair, is just an update of the long title to the Intelligence Services Act, Chair. And the underlined parts, Chair, would reflect what is now the current regime, Chair, in line with the separation. Clause 52, Chair. Thank you. For clause 53, thank you, Chairperson and members.
Can I move? Any mover? Honorable Stebe, Honorable Kolabanant.
Thank you, Chairperson and members. So clause 53 is just the schedule, Chair, which lists the laws that have been amended by, or that are proposed to be amended by this legislation. It hasn't changed, Chair. There would have been a minor change if the amendment to the Secret Services Act had carried, because it would have to be listed in that schedule as well. So now it remains as was introduced, Chair. There is no amendment there. So that's in respect of clause 23, Chair. It reads as follows. The laws specified in Schedule 1 are hereby amended to the extent indicated in the 3rd column of that schedule, Chair, which, as I mentioned, Chair, remains as is. Very minor updates where necessary. So that one is clause 53, Chair. Thank you.
Any mover? Honorable Stebe, followed by Honorable Loate.
And the last but not least clause, Chair, is a short title, which really just states the name of what this bill is, Chair, and the legislation will be known when it has been signed into law. Thank you, Chair. It says that this act is called the General Intelligence Laws Amendment Act 2023. It shall come into operation on a date determined by the President by proclamation in the Gazette. 2, It states that different dates may so be determined in respect of different provisions of this act and B, categories of intelligence entities. Chair, the only difference which perhaps I must mention with this act, Chair, is that, or at least this proposed provision, Chair, is that the president may determine different dates for commencement of different things within the legislation. Also, just to allow transition, Chair, and preparedness as we're moving from one regime to another. It's generally not an issue that you see in many legislations here, but it is allowable that the president may determine that certain sections of the act start at different times. And that's what that section, that's the effect of what that proposition, Chair. And that it will come into operation when signed and proclaimed as provided for in such sections in clause 54, subsection 1. Thank you very much, Chairperson.
Thank you very much. What do we do with the other? Oh, let me move first. Honorable Kolabanat, supported by Honorable Stebe. The other pages.
So the other pages, Chair, is the memorandum. Firstly, it's the schedule, which is a list of all the laws that are being changed and states why. And the last part, Chair, is the memorandum on the objects of the bill. So that's just the explanation of why these clauses are being changed, Chair. So it's been updated in line with the A list or with the agreed list of amendments of the committee. And is not subject of this. It's merely adopted, Chair, with the consequential amendments as they should apply.
And these countries that are mentioned in there.
That's just the background, Chair, to the amendments.
Okay.
Thank you.
Can I then get a mover for the whole bill, Honorable Loate, and supported by Honorable Kolabanat?
And Makwanisha.
Oh, supported by Honorable Bulalani Makwanisha.
Chair,
Honorable Stebe.
can we perhaps now go it through again from the beginning, see if we missed something?
That permission is not granted. Can I get direction from Nati?
Thank you, Chair. So the next step, Chair, would be to consider the report of the committee on the bill, which is the report of the committee that will go to the Assembly, Chair. After the members have adopted this bill, Chair, with the amendments as indicated. So the next step will be for us, Chair, to go and update the amendments and as adopted by members. And then that will be attached to the committee report, Chair, and sent to the House to report on the bill, Chair. Thank you. But my colleagues will also assist in
You are
this.
definitely not suggesting that we are going to sit again and do this. Those are manager.
Thank you very much, Chairman. So we have a draft report. As you were adopting, we're updating it. All we need is a few minutes to print it, go through it, adopt with amendments, and we are done.
Yeah, so we will need a 5 minutes break. Ne?
How long?
15 minutes. Thank you, Honorable Magwanisha.
Thank you, Chair.
Yeah, so it's only 15 minutes so that we adopt every other thing and 15 minutes break.
Recording stopped.
I think we can start. We are having how many sets of minutes?
Recording in progress.
I'm told this would be the last sitting of the other committee. Is that so? Okay, very interesting. And who is going to take us through? Let's start with what we have. The minutes as
The minutes of the session.
we start with today's minutes. Do I call them minutes?
It's a report.
Oh, this is a report, you know? Do we, is it not today's minutes, the report?
Yeah, there's still today's minutes, which are short.
Or do we have a separate?
Yeah, minutes.
Oh, okay, so we need to adopt the report.
Yeah, then the minutes up.
Okay. First page of the report, anything? Page 2. Page 3. Page 4. I'm on page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 8. Your mic?
Sorry, page 8. It's the new clause. I'm not sure what it is in relation to. Yes, Joint Standing Committee on Intelligence says and Deputy Chairperson. 1 bracket 4. I thought that was something that had been taken out. Am I right?
Thank you very much, Chairperson. So the report, honorable members, if you look at it, it encompasses everything that went on. It's just a summary. So that was what was discussed, which was contained in the proposals, which were referred back. So you'll see that when we get to the end, we'll get to the end where the committee reports on the interim report that was sent to NA, tabled there, then referred back to the committee. Thank you, Chairperson.
Okay, we were on page 11. Page 12. Page 13. which, okay. Page 14. Mhm.
I'll let you go back to page 13. Thank you very much, Chairperson. So if you see the paragraph number 2, page 13, yes, we make the reference to that, and the last paragraph there, it indicates at the sitting that took place today. That's what happened, and the report was referred back. The most important part is the last clause that is contained there. During clause by clause deliberations on 19 March 2024, the committee resolved to omit the aforementioned aspects of legislation.
Thank you very much. If I was to be educated on this, what happened? Is this the report that goes to the National Assembly? Very interesting. Who is going to be reading it? No, I'm just interested in the way it is written. Say if you check page 8, how do you read this?
They can always summarize the report for you. Yes. All right.
Hey, any mover? Honorable Stebe, followed by Honorable Luate, Honorable Kolabanas.
If you could look on the last page 14, it says the minority views above state the clauses and the reason why the various political parties did not support them. What is that?
So what happened, as you saw, it was the report that was drafted from other reports. So what we're going to do now, we're going to do the editing and removing of everything that is not supposed to be here. Yes, that's definitely not supposed to be here. Thank you, Chair.
It has already been adopted.
Yes.
Okay, then can we get to the minutes of the 7th of March? The 7th of March. First page. Second page. Third page. Fourth page. Fourth.
On the fourth block, I think is repeated twice. The third, page 4. Page 4, the third block starts with significance intelligence failure. The second block also is the same.
Page 7. Page 8. Page 9. Honorable Luati.
Sorry, Chair, you'll pardon me. I was reading something else where I also made a mark. With your permission, Chair, if can we go to 6? And I'm not sure on that fourth block where it talks about giving the powers of arrest. Do you give powers or to arrest? Where we speak about the members of intelligence. I was trying to figure out what the meaning was, or the intended meaning was.
That number one.
Where it says it's in the fourth block.
Apprehend,
Yeah,
confess the power.
yeah, not the minutes.
What
We are on the minutes.
Apprehend,
The
confess
minutes
the powers
of
to
the
arrest.
7th.
I think in the initial bill, we said we must take out apprehend because apprehend is unclear. It can mean anything. And surely they don't have the services can have the right to arrest.
Okay.
So I think we decided to take out apprehend.
Apprehend.
Honorable, are you still on the floor?
I just don't, I think Honorable is, he said he's got the minutes of the 7th.
Yeah, we are on the minutes of the 7th of March.
Okay, because I only got 8. I
In
only
that-
got the 7th.
Don't you have a brown file?
Yeah, but just see, maybe I'm dear Makari. Yeah, so
Okay, and we are on page. Did we go back
6.
to page 6? Yeah. Are you fine?
Yeah. No, sure.
Okay.
Yes.
All right, we're on page
9.
page 9, page 10. Page 11.
Fine.
Page 12. Page 13. A mover. Honorable Kolabanat, supported by Honorable Luate. The 8th of March, first page. Second page. Third page. The fourth page. Fifth page. Sixth page. Seventh page. Page 8. Page 9. Honorable what?
Yeah, Chair, what we were discussing a bit earlier. Let me see, am I reading it correctly? Oh, okay. No, I'm reading it correctly now. Yeah, that's 16 of the same minutes.
Okay.
Yeah, it's related to what we were talking about earlier
Okay.
in the other minutes. Yeah.
Page 10. Eleven. 12. 13. 14. 15.
Question,
Honorable Kolabana.
page 15, number 43, where it says refer, in the middle column, refer to paragraph something above. Is that supposed to be paragraph X above or the paragraph immediately above, which doesn't relate to that? What is that referring to?
I think this is what is it SSA in their responses. Isn't it somewhere they say that's how they in their report they had it like that. Or maybe it's the answer above, which would be the agency proposed the following definition in this regard. So it means maybe the repetition of any person or institution might be in all of those 44, 45. That's my understanding. Page 16. Deliberations, that would be page 17. Still deliberations, page 18. Page 19, which is the last page. The mover, Honorable Luate. Seconder, Honorable. Oh, you wanted to,
I was going to ask because I can't move because I wasn't in that meeting. Yes. These people.
Honorable Kola Bernard, supported by Honorable Stebe. Eleventh of March, first page. The first page, policy advisor, is that a title in the department? Okay. Doesn't matter anyway. Page 2. We are dealing with formal deliberations. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Page 14. Page 15. Page 16. Seventeen. 18. 19. 20. 21, 22, 23, 24, and the last page.
Chair, if I may, on the last page, 2.3, it was explained that the legal team would draft the A list and were to include the deliberation done by the committee and would include, it's just incorrectly phrased. So the A list and would include the deliberation done by the, or deliberations should be done by the committee. Yeah, so draft the A list and would include the deliberations done by the committee.
Page 4. Page 5. Page 6. Seven. Eight. 9. 10. 11. 12. 13. 14. 15. 16. 17, which is the last page. Honorable Luate.
Can I just check something, Chair? This relates to the uniformity in which we write the minutes, particularly on, if you look on the first pages of the different minutes, that in some cases under attendance, you would have the names of people as present and those with apologies, but in others, there's no name, there's nothing of any member that could probably have not been there. So you don't write, in other words, if I'm not present without an apology, you say nothing. Okay. Try.
Any mover? Honorable Luate, seconded by Honorable Kolaban. Minutes of the 19th, last batch. First page. Guest attendance, director, general office. Is that how it is? And who would this one be? Yeah, but he was there. Okay. Second page. Third page. Fourth page. Fifth page. Sixth page. Seventh page. Are these today's minutes? Eighth page. Ninth page. 10th page. Can we, on the 10th page, the committee agenda at, meaning that you'll have to put it in after we finish. We're still here. Okay. Any mover? Honorable Zagude, followed by Honorable Luate. Finito. Anything that we need to know? The manager?
Nothing.
No announcement or Okay. So what do we do now? We close the meeting and go home. If this is the last meeting, then shall we say that is borrowed the right term? We have been having officials here who did a lot of job. And surely we owe them a bottle of brandy each. No, they really did a good job. If they were not there, we would have been in trouble. Only the borrowed ones are the ones that I'm thinking. Hmm. Yeah. Yeah, I think they deserve it. I thought maybe the manager would say something from here now. What happens next week? This week we don't have a meeting. Next week, or maybe Aluto here can do that. Over to the manager. It's referring to this one. This is the very last.
Okay, so thank you very much, Chairperson. So this is the very last meeting of the committee. So the process that will follow now will do the final editing of the report and also the final editing of the bill as we have it, submit that to a service provider for the final typesetting and final editions. Then when we get that back, the report will be sent to the National Assembly. So it will be 80 seat, and then the process will be done from the committee's side. Yes, Chairperson, that should happen since we have experienced challenges with regard to the service provider delivering on time, as the delays and these late meetings. So we expect that the process, if we submit this by tomorrow midday, because we have to do a thorough job now in terms of fixing all the small mistakes that are there or errors, we should have the bill back by Friday. If that happens, then the report will be sent for ATC on Friday, Chairperson.
Okay. So we can as well go home now. Honorable Zagude.
Thanks, Honorable Chairperson. Bills always have to have 3 days. There's a 3 days rule that is required for the bill to be 80 before it's adopted in the House. So meaning that we need to do proper consultation with all political parties so that the bill is tabled in the House on Tuesday next week. Thank you, Chair.
Does tabled in the House mean? Okay. Okay, then. Can I close the meeting then, and then the meeting is adjourned. The ad hoc committee meeting is closed. And the ad hoc committee is dissolved.
Chair, just one thing. I think appreciation for the staff members who put in a lot of work here. And I think we need to thank them for that. Thank you so much, everybody.
They really did. Maybe special thanks to Nati here. He needs special attention. I could see he was exhausted every day. No, they really worked, and we thank all of them for that. Not forgetting Alut. Okay, thank you very much. The meeting is closed.